I may be pardoned. I may be pardoned to mention, Your Lordship, item 167. Kindly be taken as Your Lordship in last week it was listed as 45 item number 44 change aitla, and this week it is listed as
Adjournment order ପଶିଯାଉଛି
kindly
ତାର
be taken up
number
to
ଗୁଡା
Your Lordship.
ସେଇଥିପାଇଁ
All the co-accused persons.
will see that the number order.
My lord, I am pardon to submit, my lord, item 124, my lord. The petitioner is in custody for more than 7 years, and it was before your lordship in the month March,
7.
and it was directed to be listed in April.
list नहीं list
Aagi ଅଛି, 124. Let it be taken up today.
number
Pardon me, my lord. 207 kindly taken up today, my lord, because co-accused is already released on bail.
206, my lord. 206 may taken up today. Add up matter.
number order take it.
Item number 129, madam. Yes, madam. 129. Item 1.
Pardon to mention, your lordship.
Mr. Das जो matter order mention କରୁଛନ୍ତି ସେ list ଟା ଦେଇଦେବେ ସେ file ଗୁଡାକ ମଗେଇଦେବେ ହେଲା launch ପରେ
Item-
ତ obviously take up ହବ yes
Item 141, your lordship. It is 141, your lordship. May be taken up. Item 141.
159, madam.
133.
149.
154, lords. 141.
Item 198.
And I may pardon 191.
Item 20,
194.
item 23. We don't remember on behalf of Mr. Arijit. What? Item 20.
Item 141.
Pardon to mention, your lordship.
Pardon, Mr. Saptar. Item 270.
Pardon to mention, your lordship.
withdraw
My lord, item 229. My lord, item 229,
23
last item.
I pardon me, Lord. On criminal appeal, my Lord.
Modification
which item
229, my lord. 2020 ଜାଗାରେ my lord 22 ରେ ହେଇଯାଇଛି।
ସେଇ ବାଟ ସେଟା
198. Post rate. 1 मतलब 9 item 9.
Pardon to mention, your lordship. Item 24 and item 110, my lord.
Next.
Pardon to mention, your lordship. Babu.
IA number 851 of 24
What 197.
No 190.
197 ଲେଖା ଅଛି. Item 24.
241 of 2020 ହବ
My lord. 22 my lord ଭୁଲରେ ହେଇଯାଇଛି।
ଆଉ ଥରେ ଆସ ସେଠି IA ଟା
Pardon to mention, your lordship.
number 229
Lordship.
so this is an application for modification of the order dated 12/7/2024. It is submitted by the Land Council for the petitioner that the case number has been inadvertently mentioned as TR case number 241 of 2022 in place of TR case number 241 of 2020, and the same may be corrected. Stop. Land Council for the state has no objection. There is the rejection order. Considering the submission, it is ordered that wherever TR case number 241 of 2022 is mentioned, the same shall be read as TR case number 41 of 2020. The rest part of the order shall remain unaltered. IA is disposed of.
I want to mention, CRL 830.
Construction of reconstruction of order dated 20
Which item?
item 220. 228.
Oh,
Only for reconstruction of order dated 20
what is the report? Report of husband. At flag M 228. Just a minute. Here is the report of the Register Judicial dated 28/5/2024. Reconstruction of the order sheet dated 24/2023 with the help of copy downloaded from the website of this court is approved. Hello? Yes.
My
I beg your
lord,
pardon to mention, my lords.
the one out of list, my lord, the petitioner implicated under section 319 CRPC, my lord. I pray, my lord, kindly next week, my lord.
Pardon, my lord. Out of list, my lord.
Right.
One CRLMC, which was disposed in 2019 by quashing the coordinates, my lord. But the Railway Department has filed an IA for recalling that order since 2019, and that is pending. I made a mention before your lordship. Your lordship allowed by virtue of they have not given me.
Item 223, my lord. This is STC appeal, my lord. Bail or body is appeal, my lord. Notice is not yet to be, my lord.
223,
my lord.
Notice
me, let me
it
fix
is a SC/ST
my lord.
bail application.
My lord.
All right. CRLA 633 of 2024, item number 223. Since one of the offense is under section 3 of the SC/ST, extra copy to be served. Usual order. CD, CA will call for matter to be listed a week after.
May I pray, my lord? Item 169 and 171, my lord. My lord, last week it was listed on 47 and 49. My lord, today may taken up.
Punch for a coil.
I may pardon me, Lord. Out of list, my Lord, one CRL 465 2016 along with 4510 2016. It was fixed
Pardon,
to
your lordship. Item number 76, your lordship. Previously, your lordship directed to serve a copy of the order co-accused release on bail, my lord. I served the copy for verification. The state will verify the document. I beg your pardon to mention, my lords.
100.
I beg your pardon to mention, my lords.
Taken up today, my lord. My lord, item 188. Last occasion it was listed in 60. Obliged.
I beg your pardon to mention, my lords.
50, man. 50.
I beg your pardon to mention, my lords. My lords, item number 15, 215, criminal appeal number 326. My lords, notice has been served upon the complainant. It is an
Not
offense
able to
under
hear.
326 2020. 326 2024.
It is voice from Subuni Counter.
Item number 215.
Extra speaker here. Yes,
Item number 215, my lords.
yes.
Criminal appeal 326 2024. It's a tied up matter. Most of the accused has already been lodged on bail. Notice has been served upon the complainant.
Okay.
I am also waiting.
326.
Any other counsel want to mention?
Item
number 1.
Yes, item number 1.
Pardon to mention. Item number.
Yes, item 1, Mr. Patnaik.
467, 468, 294, and 506 of the Indian Penal Code. And the allegation in the FIR manner, one Southern Pagi had taken money from the informant manner, that is 50,000 rupees, and basing upon the co-accused Southern Pagi, the present petitioner implicated in this case, madam. And similar, this Southern Pagi already released on bail by this honorable court. That is,
keep the speaker immediately. It is not audible. Make the arrangement. ତମେ ଆଗରୁ ଆସିକି କରୁନ ଏଗୁଡ଼ା ସବୁ ହଁ କେତେବେଳେ ଆସୁଛ କୋର୍ଟକୁ? Call the CPC immediately to arrange speakers, extra speaker. Yes. Why this anticipatory bail has come before me?
my lord, it's because my lord, ABLAPL 500 of 2022 has been disposed by your lordship. That is
Order has
co-accused.
been passed in that case.
My lord, that is on 2/2/2022. He was released on bail. ABL 500 of 2020.
What is the amount of cheating?
50,000 only.
Right, yes, Mr. Das. Same order pass कर दे बस release of the co-accused taking into consideration और बाकी जा सब लेकिन allow कर दे. Yes,
My
next.
My lord, pardon to mention, my lord, 24 and 110
Yes.
my lord, may be withdrawn, my lord. May I
Item
pardon?
2.
Item 2 may plead, sir. This is the successive bail application of the present petitioner, lordship. Earlier bail application of the present petitioner was rejected by this honorable court by order dated 31st March 2023, that is annexed 2, page 14, your lordship, in which this honorable court, while not inclined to grant to the bail of the present petitioner, granted liberty to move afresh after examining the third victim, your lordship. In what offense, last 1 year, wherever the third victim not been traced out by the learned trial court, your lordship, and petitioner is being a lady and more near about 5 years inside in custody, your lordship.
All right, the learned counsel for the petitioner referred to the order dated 31/3/2023 passed in BLAPL number 10993 of 2022, in which while rejecting the bail application of the petitioner, this court granted leave to the petitioner to renew the prayer for bail after examination of the third victim. The learned counsel for the petitioner submits that even though more than 1 year and 3 months have passed since the passing of such order, the third victim could not be examined in the trial court as or whereabouts is not known, and the petitioner is a lady and she is in judicial custody for about 4.5 years.
What? 9/11
The
2009.
learned counsel for the state shall produce the custody certificate, so also the case diary. A report be called for from the learned trial court, that is so and so in so and so case, as to why there is delay in examination of the third victim as submitted by the learned counsel for the petitioner. Put of this matter on such and such day. File be placed before registered judicial usual order. Yes.
Okay.
Item 3.
Item 3.
Item
Yeah,
3 and 150. I have mentioned, my lord. I in 150 item I have supplied the deposition and everything, my lord. So that I have mentioned take up after lunch, my lord.
my lord,
With
the matter has been fixed to tomorrow. Accused statement is over, and a matter they have taken thrice time to produce the defense.
Statement stage rachi.
Sorry, Galani. Accused statement, sorry, Galani. Tomorrow it has been.
And counsel for the informant submitted that the accused statement has already been recorded, and the case is now posted
To tomorrow.
to tomorrow for defense. In
Defense twice they have taken time last times.
Defense in view of the stage of the trial, while not inclining to release the petitioner on bail, the learned trial court is directed to conclude the trial, preferably within a period of 2 months from the date of receipt of this order. This copy of the order be communicated to the learned trial court.
one thing, my lord, friends, I have no instruction to that.
No instruction. The learned counsel for the petitioner submits that he has no instruction.
And my lord,
And
co-accused person has been.
you return the money which you have taken from your client without any instruction. You
My lord,
are
as per instruction, my lord, co-accused
item
person.
number. What is the other item?
Say the co-accused person so bail
Item number 150.
My lord, item number 150, my lord. I am on the similar footing. Your lordship has granted bail to all the co-accused persons.
All right, argue the case and judgment will
My lord,
be
let 150 may be reached, my lord. So I
sorry,
will,
sorry.
my lord,
Rejected. Next.
Obvious.
Item 4.
May I please? Petitioner is in custody since 29/7/2021 महिला.
Yeah.
Allegation of 20B2C of NDPS Act महिला. Trial has not been commenced. Previous bail application, the petitioner was also filed.
What is the order passed in the previous bail application?
That order is not available in the website, but it is in flag A महिला.
Flag A.
महिला. I'm noting.
Since when you are in custody?
29/7/2021.
এপর্যন্ত সাক্ষী আরম্ভ হয়নি?
সাক্ষী হয়নি.
All right, the learned counsel for the petitioner submits that the petitioner is in judicial custody since 28/7/2021.
29/7.
29?
28 FI, 29 he was forwarded.
29/7/21 though. And he has instruction that not a single witness has been examined in the trial court. Stop. In view of such submission made by the learned counsel for the petitioner, let a status report be called from the learned trial court. The learned counsel for the state shall also produce the case diary, so also obtain instructions about the criminal antecedent, if any, against the petitioner. Yes, a week after. No?
Item 5.
may plus 20B2C. This is the third bail application. Now, my lord, the lordship granted the interim bail in BLAPL number 5850 of 2023. Interim bail was granted. Now, my lord, after my lord, he is in custody since 2021. Lordship may call for the status report. As per my instruction, only 5 to 6 witnesses have been examined.
Status report be called for. CDCA be called for. The learned counsel for the state shall also obtain instruction to the inspector in charge of Baliguda police station as to whether there is any adverse report against the petitioner to have misutilized his liberty while on interim bail granted by this court in BLAPL number 5850 of 23 as per order dated 1/2/2024. Free copy of the order be handed over to the learned counsel for the state.
Item 6.
May I please, my lord? 20B2C of NDPS Act. The petitioner was not present in the spot. The petitioner has surrendered before the learned court below pursuant to order passed by this honorable court in CRLMC number 1454 of 23 by the order dated 12 to 20.
When you surrender?
24/5/24, my lord.
Have you received the case diary, Mr.?
No, madam.
All right. The learned counsel for the petitioner submitted that
Last page of the rejection order, madam.
last page. Annexure 3.
23 page.
The
The case relates to 2014 and the case has been twice split up for the non-apprehension of the present accused. The same some co-accused person are yet to be apprehended if they release.
କଣ ମାନେ ଆଗରୁ ଜମା ଧରା ହେଇନି ନା ଧରା ହେଇ ପୁଣି ପଳେଇଲା?
ନାଇଁ ନାଇଁ ମୋଟେ ଧରା ହେଇ Antecedent ଫାଇଲ ହେଇଥିଲା CRLMC order ଅନୁସାରେ latest order ଅନୁସାରେ surrender କରିଛି.
The learned counsel for the petitioner submitted that the petitioner
surrendered pursuant to order dated 12 to 24. 12 to 24 CRLMC 1454/23.
12/2/2024.
ଆଜ୍ଞା.
Passed in
CRLMC number 1454 of 23.
देखिए ठीक से the learned counsel for the state submit that he is yet to receive the case diary, so also instruction regarding criminal antecedent, place this matter on such and such date.
Item 6. Item 7.
FIR against unknown person, my lord. All the co-accused person has already been granted bail, my lord, by the Hon'Ble court. I am in the similar footing, my lord. I have annexed the.
Have you received the case diary?
No, my lord.
Who is the accused who has been released on bail? Which accused you claim
All,
parity?
my lord, there are 6 number of accused persons, my lord.
No, who accused ସାଙ୍ଗରେ ଆପଣ parity claim କରୁଛନ୍ତି? BLAPL number?
BLPL these are unknown FIR, my lord.
ଓହୋ
ଆଜ୍ଞା
ଆପଣ କୋଉ accused bail ରେ ଯାଇଛି ଯାହା ସାଙ୍ଗରେ parity claim କରୁଛନ୍ତି?
BLPL number 156 2020.
ତା ନାଁ ହଉଛି ଦିଲ୍ଲୀପ ମହାରଣା.
My lord.
All right. The learned counsel for the petitioner submitted that the petitioner is similarly situated like co-accused Dilip Maharana alias Dhuma alias Bhutta,
my lord,
who has been directed to be released on bail by this court in BLAPL number 156 of 2020,
my lord,
as per order dated 27/5/2020. Stop. Learned counsel for the state seeks some time to produce the case diary, so also obtain instruction about the criminal antecedent.
my lord,
Let the learned counsel for the state examine the claim of parity put up this matter on such and such date. Yes.
my lord, I am filing the affidavit, my lord. My
What affidavit?
antecedent, so far the antecedent concern. I have 11 number of
The
antecedent.
learned counsel for the court have you filed?
My lord.
The learned counsel for the
Today.
Petitioner files affidavit relating to the status of the criminal antecedent against the petitioner, copy of which has been served on the learned counsel for the state in court today, who also seeks time to obtain instruction. Yes.
Item 8.
May I please, Your Lordship? My lord, it's a Belgium matter. Page 15, in the rejection order, it has been reflected. Second para, 5th line, my lord. Bobby Maji surrendered before this court on 19/4/2024, and Lingru Maji produced in court on 27/3/2020 on the strength of production bar.
No, where is the voluntarily surrender?
My lord.
You are, what is your name?
My name is Bobby Maji.
Bobby Maji.
My lord.
So it is mentioned that submitted that the Bobby Maji voluntarily surrendered on 19/4/24.
My lord.
From that, how can it be known that you are on bail?
My lord, I have given bail order copy, but I have given that I have on bail from the learned court below on 19/12/2007.
Where is the bail order? Please pass on the bail order.
I say copy.
Then somebody is surrendering voluntarily.
Warrant copy I only annexed, my lord.
Warrant maybe when you are absconding also without surrendering or without taking into custody, that also warrant can be issued. So if it is a Belgium matter, your duty is to produce the bail order. Nothing has been mentioned also that
I have
you are on bail.
stated, my lord, in
you are stated, so they have to take instruction on that.
19/12/2017.
The learned counsel for the petitioner submitted that it's a Belgium matter, and the petitioner was on bail but defaulted in taking steps before the London trial court, for which non-bailable warrant of arrest was issued against him, by virtue of which and he voluntarily surrendered on 19/4/2024. The London counsel for the petitioner, however, has not filed the copy of the bail order and seeks some time to produce the same. Aro saptah rakhivi. Put up this matter on 26th of July 2024. The London counsel for the petitioner shall produce the certified copy of the bail order.
So far as petitioner 2 is concerned,
He was granted bail by
Provision
this honorable.
and so also the bail order of these both the accused persons,
My lord.
both the petitions. Yes.
Item 9.
Rajiraji ଗୋଟେ surrender କରିଛି ଆଉ ଗୋଟେ taken into custody rejection order ଏଇଟା ଏକ ଲେଖିଲି ହେଲା petition number ଇଏ ହଉଛି surrender କଲା ଆଉ petition number 2 ହଉଛି ସେ ହେଲା yes
May I please proceed? Petition as apprehending their arrest for alleged offence under section 341, 323, 307 and 34 IPC. Last occasion, lordship directed to produce the case diary along with the injury report.
what is the allegation against you
My lord, allegations, my lord, while the interim murder is came into force,
କଣ ହେଇଛି
while the interim murder is came into force, the petition of two already arrested by the IO and produced before the
no 307
307 allegation is that
whom you have assaulted and what is the injury sustained have you received that
No, man. Anil Pradhan was injured, my lord.
Anil Pradhan have you got the copy of the
no
then
He was also shifted to AIMS, my lord, and he has also undergone surgery and shifted to ICU.
all right pay you the first information report annexed to the bail application as annexure 1 from which it reveals that the injured is one Anil Pradhan who after the assault was admitted to Kims লেখা হয়েছে Mr.
as per instruction, Lord, injury is simple in nature.
In the ICU and is fighting for his life. The land council for the state seeks some time to produce the case diary as well as the health condition of the injured. Put up this matter on such and such.
Interim order interim order already there.
Who did?
Ithiraj.
Kebe order hitla phone.
Interim order is
all right till next date the interim order dated 12/1/2024 shall continue. Yes, next.
Item 10.
Lordship, on behalf of Mr. Ponda, pass over.
Yes, there you see there.
Na case
307 case no asini case କଣ ଆଦିର ଅଛି how many petitioners are there one Manjulata Jena what role has been attributed against her Manjulata ପନିକି ଆଣି ମୋ ସ୍ୱାମୀଙ୍କର ବାମ ହାତକୁ ଆଣି ରକ୍ତସ୍ରାବ କରାଇବା ବେଳେ ମୋର ଶାଶୁ ଅଟକାଇବାରୁ ମୋର ଶାଶୁଙ୍କୁ ତାଙ୍କର ମୁଣ୍ଡ ହାତ ନାକକୁ ପ୍ରହାର କରି ଆଘାତ ସୃଷ୍ଟି କରିବା ସହିତ ଜୀବନରୁ ମାରିଦେବାକୁ ଭୀତିପ୍ରଦ ହତ୍ୟା ଧମକ ଦେବା ସହିତ ମୋର ଘରଟିକୁ ପୋଡ଼ି ଦେବାକୁ ଦୃଢ଼ ଚେତାବନୀ ଦେଇଛନ୍ତି so he has annexed the medical examination report all the injuries 3 injuries are grievous 2 are simple charge sheet submitted so you obtain instruction it is a charge sheet dated 27/4/21 whether processes under 80 to 83 has been issued or not where you the charge sheet of the case annexed to the bail application as annexure 5 from which it reveals that the same was submitted on 27/4/2021 inter alia for commission of offence under section 307 of the Indian Penal Code and You are shown as not arrested. And why are you seeking for anticipatory bail? In the charge sheet,
Lordship, I am not going through the brief, Lordship. He requested me for the pass-over, Lordship.
while submitting the charge sheet, the petitioner has been shown as not arrested. Stop. Let the learned counsel for the state obtain instruction as to whether there is any apprehension of arrest of the petitioner in connection with this case or not. Put up this matter on 26th July 2020. Yes.
Item 11.
May I please your lordship? My lord, in the last occasion, your lordship directed my learned friend to obtain instruction regarding the any meeting is going on or not.
Petition number 1 is the husband. Petition number 2 is the mother-in-law of the informant.
My lord.
Case arises out of matrimonial dispute.
My lord.
And though the injury sustained by the informant has been opined to be grievous, but case as an interim measure, okay. So, extra copy was directed to be served on the learned counsel for the state.
Yes, I let it be next week. I have not received the instruction. I have already sent the letter.
That notice is to be served on the informant. All right, the learned counsel for the state
submission, my lord,
seeks some further time to apprise this court whether the notice on the informant has been made sufficient or not. Put up this matter on 2nd August 2024.
My lord,
interim order dated 28/6/2024
my lord,
is extended till next date.
Pleasure.
Item 11.
11 to Sola.
Item 12.
Pass over, my lord.
Sorry, what take Mari. Yes, item 12.
Pass over, my lord.
NDPS matter
so NDPS रे anticipatory bail कौन पे दिया जीवो surrender कौन तो move कौन
no my lord 2 1 on behalf of Mr. U Jenna, my lord, just has given file, my lord, 21 cops Europe, my lord.
so it's surrender
and other co-accused persons released on bail, my lord.
अच्छा. The learned counsel for the petitioner submits that some of the co-accused persons have been released on bail and the petitioner is ready and willing to surrender in the court below and move for bail, and the claim of parity be taken into account. The land counsel for the state has no objection. In view of such submission, it is ordered that in the event the petitioner surrenders in the court of learned session judge cum special judge Balangir within a period of 4 weeks from today and move an application for bail, the same shall be disposed of expeditiously, preferably on the same day, and claim of parity to be taken into account in accordance with law. Yes, diary shall be made available, disposed of. Yes.
Item 13.
May I please, your lordship? On the last occasion, your lordship, on the basis of the orders in respect of co-accused persons filed by me, directed to State Council to take instruction. Here, the petitioner of your lordship
was directed to produce the case diary.
My lord, here the petitioner.
I received.
What is your instruction? Same putting or?
This is antecedent bail, and the two co-accused persons is on regular bail.
Regular bail or anticipatory?
Now, one in 482 directly released on bail,
and another
2 regular bail. 3 orders I had produced. Jiten Raut was released on bail in a 482 application.
What is the allegation against you?
That the amount was received for the purpose of training in that consultancy firm where I was a coordinator and getting 7,000 per month. I was employed there. The main persons are somebody else, not we. Even I had taken training in that consultancy firm by paying an amount of 3 lakhs. And now
Only allegation, my lord, is that
we are just collectors, my lord, for the principal.
yes, as per the co-accused Deepika Banerjee, the petition complainant transferred 2 lakhs to the account of the Probin Patra. This is the only.
Deepika has been released on bail. Jiten Raut, my lord, against whom similar allegation like the petition has been made, he has been directed to be released on bail in a 482 application. And another Prashant Das, please Pratap Kumar Satpathy has been released on. He just an employee, your lordship.
Where have you stated that he was?
Now that your lordship will kindly peruse page just
No, any averment has been
yes,
taken?
getting 7,000 per month, paragraph 3, page 3 of the bail application. Probin Patra initially was appointed as a coordinator monitor to maintain discipline in the training class for about 1 to 2 years. Performed in Swanso Jamsu Golmari. The training and other functions are conducted by Chaitali Mukherjee. He has been released on bail. Shiv Kumar and Prashant Das. Prashant Das has been released on bail. Probin was getting salary per month rupees 7,000, sometimes with effect from 2018. Salary of
counsel for the petitioner and counsel for the state. The London counsel for the petitioner submitted that the offences are triable by magistrate, and some of the co-accused persons have already been released on bail, and he has mentioned the same in paragraph 5 of the bail application, and submits that the petitioner was appointed as a coordinator, public monitor in NTPF Jamshedpur Golmari, and he was getting a salary of rupees 7,000 per month. And in view of the nature of accusation against him, the anticipatory bail application may be favorably considered. Land counsel for the state produce the case diary, be clear for bail, considering the submission made by the land counsel for the respective parties, nature of accusation against the petitioner, the release of the co-accused persons on bail, and since the offences are triable by magistrate and inclined to release the petitioner on anticipatory bail allowed.
obliged.
Item 14.
Please, Lordship. Lordship, case 353-506 and non-bailable offence, Lordship. Present petitioner is lady, and in the meantime, some of the co-accused person granted bail by this honorable court, that is marked as flag K, Lordship.
Flag A.
Yes, Lordship.
A. Yes, Mr. Dar. Considering the submission made by the London counsel for the petitioner that the petitioner is a lady, and co-accused persons have already been granted anticipatory bail in ABLAPL number 5488 of 2024 as per order dated 30/5/2024, and it's a case and counter case, and the allegation against the petitioner are omnibus in nature, and after hearing the land counsel for the state, I am inclined to, and keeping in view the proviso to section 437(1) CRPC, I am inclined to release the petitioner on anticipatory bail allowed.
Oh, please.
Item number 50 kindly pass over. Item number 50 kindly pass over.
My lord, interim order में interim order में kindly भी
Baba Singh,
He is for the informed, and the petition counsel is there in it.
You are for the informer. Yes, what order was passed?
Last order submitting the report, my lord.
Submitted that the co-accused Srimati Puspa Sethi, who is the wife of the petitioner, has already been granted bail in so and so, and the cheating amount as per the first information report is so and so, which has already been returned to the informant, and the same would be evident from annexure 2 to the bail application. Learned counsel for the informant wants to obtain instruction on this submission and file a specific affidavit whether he has received back the cheating amount or not. Okay, as an interim measure, कौन हला सेटा? Finally, there is total
due जोड़ा amount আছে finance.
I may clarify so and so. Mr. Saran,
Yes, my lord.
report of the IIC Denkanal Sadar Police Station, which is dated 18/7/2024, is produced before me by the London Additional Government Advocate, and it is mentioned that cash of rupees 17 lakhs 5,870 is still to be paid to the informant G. Parmeshwar Rao.
Yes, my lord. In their objection filed by the informant as advocate, it has been mentioned in para 5.
That is the report. Everything has been taken into account. So the outstanding dues is this. So when you will deposit this amount in the court below?
My lord, we have paid that from 15 lakhs and 31
You have not paid the outstanding dues is still 17 lakhs 5,870. That is the report. Whether you will pay or I will vacate the interim order.
My lord, I have paid 15 lakhs with 31,270 on
that is taken into account, but the outstanding dues is 17 lakhs and odd.
Out of 17 lakhs, I have paid that for 15 lakhs.
Are the learned counsel for the petitioner, Mr. Saran, to virtual mode, the learned counsel for the informants, also the learned counsel for the state. As for the order dated 5/7/2024, the learned counsel for the state has produced the report of the IIC Denkanal Sadar Police Station dated 18/7/2024, wherein it is mentioned that a total amount of rupees 17 lakh 5,870 is still due on the petitioner to be paid to the informant G. Parmeshwar Rao. This court made a query to the land counsel for the petitioner as to whether the petitioner is ready and willing to deposit such amount in the court below. The land counsel submitted that the petitioner has already paid the amount to the petitioner. In view of such submission, I am not inclined to release the petitioner on anticipatory bail stands rejected. Interim order stands vacated. The petitioner is at liberty to surrender in the court below and move for bail. Same shall be disposed of by the courts below expeditiously.
My lord, parity will be considered.
Claim of parity be taken into account. Yes, next.
Judgment.
This report is taken into on record.
Item 16.
Item 16, Lordship, petitioner husband, Lordship.
Please.
Husband.
According to the informant, my lord, my name has not been indicated in call list, my lord. And
yes,
Your Lordship, offense Lordship 307 for 98 Lordship. FIR has been lodged after 2.5 years, Lordship. The 307-year concerned Lordship trying to kill by pressing a pillow, Lordship. Lordship, petitioner happened to be civil engineer.
You said?
Lordship, pillow, pressing to pillow.
What is the delay you said?
Delay 2.5 years have been lost the FIR.
2.5 years.
Lordship, after she left the house from the petitioner, she stated
Mr.
that in
Counsel, the date of occurrence
Lordship,
in the first please listen to me. The date of occurrence as per the first information report is 30/3/2024 and the FIR is lodged on 24/4/2024. So where is the
Lordship, here Lordship, the marriage has been solemnized on 1/12 Lordship. She was left the house from 11/12/21. FIR कौची से अबे ग्लास Lordship page 17.
17 ଲର୍ଡ଼ସିପ୍ କହୁଛି 11 ଡିସେମ୍ବର 2021 ତାରିଖରେ ସେ ମାନେ ଦ ପିଟିସନର ଲେଫ୍ଟ ଦ ହାଉସ୍ ଟୁ ଜଏନ୍ ଦ ସର୍ଭିସ ଲର୍ଡ଼ସିପ୍ ଆଣ୍ଡ ସି ଲେଫ୍ଟ ମୁଁ ମଧ୍ୟ ଭଉଣୀର ଦେହ ଖରାପ ହେବାରୁ ଡିସେମ୍ବର 15 ତାରିଖରେ ବାପା ଘରକୁ ଆସିଗଲି। ଭଉଣୀର ଦେହାନ୍ତ ହୋଇଯିବା ପରେ
You are the husband.
ଲର୍ଡ଼ସିପ୍ 307 ଲର୍ଡ଼ସିପ୍ ଟ୍ରାଇଡ୍ ଟୁ ପିଲ୍ ଦ ଇନ୍ ଲର୍ଡ଼ସିପ୍ she was stated 24/12 ରେ
How many years of after marriage you have done this to your wife? କେତେ ବର୍ଷ ପରେ?
ଆଜ୍ଞା
ବାହାଘର କେବେ ହେଲା?
ବାହାଘର ଲର୍ଡ଼ସିପ୍ ହେଲା 1/12/21 ଲର୍ଡ଼ସିପ୍ 21।
ପିଲାପିଲି କଣ ଅଛି?
ପିଲାପିଲି ଲର୍ଡ଼ସିପ୍ ସେ 14 ଦିନ ପରେ ବାହାରିଗଲା। ତାପରେ ସେମାନେ ଆଉ ମିଶିକି ନାହାନ୍ତି କି ଟିଲ୍ ଲଜ୍ ଦ ଏଫେୟାର ସି ୱାଜ୍ ତାଙ୍କ ସାଙ୍ଗେ ସମ୍ପର୍କ ଥିଲା। ସି ୱାଜ୍ ସଫରିଂ ଫ୍ରମ୍ ସମ୍ ୟୁଟ୍ରସ୍ ପ୍ରୋବ୍ଲେମ୍। ସି ୱାଜ୍ ଗିଭ୍ ଦ ମନି ଅଲସୋ ସବୁ ହେଲା। ଆଫ୍ଟର 2023 ଲର୍ଡ଼ସିପ୍ ଏଫେୟାରଟା ଲସ୍ କଲା। ଇନ୍ ବିଟୱିନ୍ 2 years ତାଙ୍କର ସେ ଟ୍ରାଏ ଟୁ
ଆପଣ ତାଙ୍କର ସିଏ ଶୋଇଥିଲା ବେଳେ ନା କଣ ତାଙ୍କ
ଆଜ୍ଞା
ଘରେ
ସିଏ
ତକିଆ ପକେଇ
ସିଏ ଆଫ୍ଟର ଲର୍ଡ଼ସିପ୍ 24/12/21 ରେ କହୁଛି। ମ୍ୟାରେଜ ହେଲା ଲର୍ଡ଼ସିପ୍ 1/12/21 ସେ ଘରୁ ଗଲା ଲର୍ଡ଼ସିପ୍ 15/12/21 26/12/21 ରେ ସେ କହୁଛନ୍ତି ଟ୍ରାଏ ଟୁ ଲର୍ଡ଼ସିପ୍ ପେଜ୍ 17 ଲର୍ଡ଼ସିପ୍।
Why anticipatory bail will be granted to you?
Lordship, petitioner working as a civil engineer, Ames Lordship, and informer also working as a manager Lordship.
How much amount you have paid to your wife since?
Lordship, I am giving the copies Lordship, ଲକ୍ଷେ ଟଙ୍କା ଏମିତି Lordship page 45 ଲକ୍ଷେ ଟଙ୍କା ଦେଲି ତାଙ୍କ ଟ୍ରିଟମେଣ୍ଟ ପାଇଁ during the before going file the FIR Lordship. After 10,000 ତାଙ୍କର ୟୁଟ୍ରସ୍ ପ୍ରୋବ୍ଲେମ କ'ଣ ଥିଲା ବୋଲି I am giving the money for the
Any
treatment.
other proceeding is pending between the parties?
No, my lord.
In the family court or anywhere?
No, my lord.
My
lord,
So whether the statement which he is giving is correct, that he has also
not
paid.
correct, my lord.
Huh? File
Statement
an
is not correct.
affidavit that
My lord, will file an
he
affidavit.
has made. He has not, because he is filing the
Again,
account statement for
Transfer.
transfer of money, Annexure 3 series. Have you received the copy of the bail application?
No, I have not
Mude
received.
Then you do not know what is the aberments and
My
you are simply nodding the head. ସେ ଲେଖିଛନ୍ତି ମୁଁ ଏଇ ଟଙ୍କା ଏଇ ଦିନ ଏମିତି ପଠେଇଛି ତାଙ୍କର ଆକାଉଣ୍ଟ କୁ ଏବଂ ତାର ଡକୁମେଣ୍ଟାରୀ ପ୍ରୁଫ ଅଛି।
I will file an
ଆପଣ
affidavit.
କହୁଛନ୍ତି ନାହିଁ।
I have paid 7 lakhs or more.
It's
to
all
his
right.
account. My
When
lord.
I'm asking a
My lord,
pertinent
I will
question
file an
to you,
affidavit.
let a copy of the anticipatory bail application. When you have filed your vinama,
On 15th, my lord.
କାହା ନାଁରେ ଅଛି vinama?
Mr. D.K. Das and advocate. I am Mr. T.K. Patnaik.
D.K. Das and associates को नारे अछि ये टाइम.
My lord, my lord.
It is stated at the bar that D.K. Das and associates have filed power for the informant. Let the registry place the vinama on record and the name of the land and counsel for the informant be reflected in the cause list henceforth. Stop. The land and counsel for the petitioner shall serve a copy of the APL.
କପିଟା ଦେଇଥିଲି ତ ସେ ଯାଇଥିବ
କଣଟା କାହାକୁ ଦେଇଥିଲେ? ମୁଁ କଣ ଅର୍ଡର କରିବାକୁ ଯାଉଥିଲି? Copy of the ABL APL be served on the land and counsel for the informant during course of the day. Will obtain instruction on the same. The matter be listed on 2nd of August 2024. Both the land and counsel, since the petitioner is the husband of the informant and the case arises out of a matrimonial dispute, both the land and counsel for the parties shall obtain instruction as to whether there is any chance of amicable settlement between the parties or not. And if any other proceeding is pending or sub judice in any other court between the parties. Put of this matter on 2nd August 2024 as an interim measure, interim protection is granted. Yes.
Item number 17.
May it please, my lord. May I prefer an adjournment, my lord?
It's a 2021 matter. Why adjournment will be granted?
I was directed to file a comprehensive affidavit before this honorable court.
No, I am disposing of the case. You file a fresh application. BLAPL of 2021 cannot
What
be.
happened, lordship? The petitioner belongs to Madhya Pradesh, lordship.
Whatever
And
it
in
may
the
be,
meantime, I have
21 bail application In 2024, you are seeking for adjournment. I am not inclined to grant.
Your Lordship, what happened that the father of the petitioner is residing at Madhya Pradesh?
Write a phrase one. Look on this is the learned counsel for the petitioner seeks for an adjournment. Mr. Sarthak Naik, learned special public prosecutor for CBI is present through virtual mode. Since it's a bail application of the year 2021, I am not inclined to adjourn this bail application since the case has already suffered 12 adjournments. Therefore, the bail application is disposed of. The petitioner is at liberty to renew the prayer for bail.
Lordship, may I request one more thing? File an adjournment to file a comprehensive affidavit, let the same be noted.
File a phrase application, not in a 2021. Yes, next.
Item 18.
May I please, my lord? In this case, your lordship has right in the last occasion to file the phrase local surety, my lord. My lord, the petitioner unable to arrange the local surety, my lord.
Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner submitted that the petitioner is unable to arrange the local surety. The petitioner is a man from
West Bengal.
Murshidabad district in state of West Bengal, and the offences alleged against the petitioner are under section 20B2C of the NDPS Act. Therefore, I am not inclined to release the petitioner on bail. The trial court is directed to expedite the trial and conclude the same within a period of 6 months since the petitioner is in judicial custody. 16/3/2020. Copy of the order be communicated to the learned trial. Yes, next.
Item 19.
My lord, may kindly see the order dated 5/7/24.
Yes.
Yes.
So you are in custody since when?
My lord, I am in custody since the order filed. My lord, 29/9/2020.
You are apprehended at the spot.
Yes, ma'am.
And what the status report indicates?
Your
Status
lordship
report
had,
is old one.
yes, your lordship had called for status report on 13/1/23. And on 5/5/23, your lordship has passed an order that out of 28 charge sheeted witness, 9 witnesses have been examined.
Your earlier bail application was rejected.
Yes, ma'am.
How many times?
My lord, my bail application was rejected once. BLAPL 2376 of 2021 disposed of on 9/11/2021. I have given the certificate, ma'am.
Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 29/9/2020. As he was apprehended at the spot. While carrying contraband ganja of commercial quantity in a truck. The petitioner earlier approached this court for bail in BLAPL number 376 of 2021 and by order dated 9/11/2021, the bail application was rejected taking into account the quantity of ganja seized, so also bar under section 37 of the NDPS Act. The learned counsel for the petitioner submitted that in the trial court, how many witnesses have been examined?
My lord, out of 28 witnesses, 9 have been examined.
Which order it reveals?
My lord, order dated is my lord, 5/5/2023.
That as per the status report submitted by the learned trial court, out of 28 charge sheet witnesses, 10 witnesses have been examined. Since the petitioner belongs to state of Bihar, the learned counsel for the state was asked, address verification
Yes, my lord. On 22/9/2023, your lordship has noted that.
Was asked to verify the address of the petitioner as mentioned in the cause title, and it is reflected in the order dated 22/9/2021.
23, my lord.
23,
my lord. 22/9/2023.
22/9/2023. No, that is the additional affidavit filed by your brother-in-law.
No, my lord, may kindly see. Learned counsel for the petitioner submits that an additional affidavit has been filed by the brother-in-law of the petitioner on 7/7/23, wherein it is indicated the petitioner.
No, the state council was given the additional affidavit on that day.
Yes, your lordship has said that Virendra Kumar Yadav is a permanent resident of such and such, and furnished in the bail application is genuine and correct one, and the police has never visited the house and ascertained the.
That's all right. I'm telling that when the state verified that address, pass on the report where your verification is there. Because the order dated 14/12/23 indicates that you failed to verify it. You submitted, sought for instruction, but you could not get it. So after 14/2/2023, whether any communication has been received that the address of the petitioner as per the cause title is a correct one.
Let me.
You made a submission before this court just now, Mr. Tripathi.
Yes.
That you have verified the address and found it to be correct. On what basis you say so?
Yeah, he says so.
No, he says so. Whatever he says, I cannot. You are to say the
Yes,
time has been granted to you to verify and say, and I have to note it down in my order. What he says, that's different.
So affidavit do. It.
Virendra Kumar Yadav is not residing
At
village
Kolua.
Kolua under so and so.
Yes, Aroma.
However, the Xerox copy of the letter so and so is sent herewith for kind perusal. Then what happened?
I had filed additional affidavit of brother-in-law of the petitioner, Sunil Kumar, and Aadhaar card also.
Yeah. As per the order dated 14/12/2023, when the Learned Counsel for the state submitted that even though instruction has been sought for to verify whether the address furnished by the petitioner in the cause title is correct one or not, but no instruction has been received since 3 months was going to be passed, this court asked the Learned Counsel for the petitioner to supply the names, address, and documents of two local sureties who are interested to take the petitioner on bail. Accordingly, the Learned Counsel for the petitioner supplied সেটা কাহিনী সে document যেটা verifiable. To the Learned Counsel for the state, and today the Learned Counsel for the state has produced the written instruction dated 18/7/2024 from IIC of Mona Police Station that the two bailers of the locality, namely Felice Naik and Gopinath Naik, are permanent residents, and their documents are genuine and there is no criminal antecedents against those two bailers. The written instruction is taken on record. Considering the period of detention of the petitioner in judicial custody and the slow progress of the trial, and since in spite of repeated opportunity being granted to the state, the Learned Counsel for the state has failed to obtain instruction whether the address mentioned in the cause title is correct one or not. I am inclined to release the petitioner on bail while not inclining to so and so on bail on merit because of that bar under section 37. I am inclined to release the petitioner on bail, interim bail, for a period of 3 months, and subject to condition that he shall appear before these two persons, namely so and so, shall be the sureties for the petitioner, and he shall appear before the Learned Trial Court on each date, and the case is posted for trial, disposed of. My lord.
Item number 20.
May I please, Your Honor? May I please, my lordship?
Yeah.
My lordship, as per the direction of my lordship, I have submitted two local sureties, namely Bitika Laki and Pulka Apparao, on 1/5/24.
Just a minute. It's you have to go. Audible.
I have submitted two local sureties, namely Bitika Laki and Pulka Apparao, on 1/5/24, who are interested to take bail to the petitioner.
Yes, Mr. Tripathi, what has happened?
Yes,
So when you are taken into custody,
My lordship, since 21/7/2022.
20,
21/7/2022, my lordship.
22. And what the status report indicates, out of 11 witnesses, 6 witnesses have been examined. You are a man from
Bihar, my lordship.
Bihar.
Yeah.
The address verification has been made.
Done.
Yes, my lords. Criminal antecedent also been done.
Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 21/7/2022. And in the trial court, out of 11 charge sheet witnesses, 6 witnesses have been examined so far, which would be evident from the status report furnished by the learned trial court. He further submits that in view of the delayed disposal of the trial, the petitioner may be granted interim bail for some period. Since the petitioner belongs to West Champaran district in the state of Bihar, the learned counsel for the state was asked to obtain instruction as to whether the address furnished in the cause title is correct one or not, and the learned counsel for the state has obtained instruction in that respect, and in the order dated 23/2/2024, it is mentioned that the address furnished by the petitioner is correct one, and there is also no criminal antecedent against the petitioner. The learned counsel for the petitioner furnished the names, address, and documents of 2 local sureties, namely Puloko Apparao and Bidika Laki, to the learned counsel for the state for verification. And today, the learned counsel for the state has produced the written instruction received from IAC Chandili Police Station dated 7/7/2024, wherein it is mentioned that the documents of the local sureties have been verified, and the sureties are also willing to take the petitioner on bail, and the report is taken on record considering the submission made by the learned counsel for the respective parties. In view of the quantity of ganja seized and bar under section 37 of the NDPS Act, while not inclining to release the petitioner on bail, of the trial, I am inclined to release the petitioner on interim bail for a period of 3 months, subject to condition that Pulaka Apparao and Bidika Laki shall be the 2 local sureties for the petitioner.
The order by order dated 5/7/2024.
The 376 AB matter notice sufficient.
19/4/23।
अच्छा. Out of 21 charge sheet witnesses, 13 witnesses have been examined, including the victim girl. 19/10/23, the victim has been further cross-examined by the learned defense counsel on recall. On so the special public prosecutor declined the rest of the charge sheet witness on the same day. Statement has been recorded. Learned defense accused do not want defense evidence so on so argument stage relevant. Heard the learned counsel for the petitioner, learned counsel for the state. Period the status report submitted by the learned trial court, which reveals that after the recording of the accused statement, since the defense declined to adduce any evidence, the case is posted to 27/2024 for argument. In view of the stage of the trial, I am not inclined to release the petitioner on bail. Dismissed. Yes, next.
Item number 22.
Yes. The Republic of India. Where is Mr. Nayak? Yes.
In terms of the order dated 12/7/2024.
12/7.
12/7/2024.
Submitted that the affidavit which is sought to be filed by a responsible officer as per order dated will be filed on 15/7/24. Let a copy of the affidavit be served on Mr. Pradhan and Counsel. Yes.
They have served a copy on 15/7. So let's say have a glance to page 13 of that affidavit.
Affidavit.
Yes.
That is filed by Ranu Chaudhary,
Okay.
who is at present the Deputy Superintendent of Police, CBI SCB Bhubaneswar. Which paragraph you want to say?
That will also come to page 13.
1-3.
1-3.
Yeah.
That starts from submission with regard to genuineness of the bailer furnished by the petitioner in the instant PLAPL number such and such. But there are two bailers, name is one is Brundan Parida and second one is Shabindra Ponda. The reply is Roman 2. Roman 2. They have stated both are habitual bailer and they are doing professional work since 10 to 12 years at Bhubaneswar.
Yes.
Got it. Now, I received instruction, both the bailers are remain present in the court. During their lifetime, they have never stood as a bailer in respect to any of the accused. This is my first submission. Second submission is, but so far as
Mr. Pradhan,
my lord,
when a responsible officer in the rank of Deputy Superintendent of Police is filing such an affidavit that these two bailers whose names you have furnished are professional bailers and they have taken so and so 10-12 वर्ष हेलानी से. So if you want to controvert it, file an affidavit of those two bailers, let it be verified.
Your Lordship,
Here I am not supposed to take evidence here.
No,
If
correct.
you file,
Absolutely
so,
correct, my lord. Absolutely correct.
so
Lordship, may kindly
Because
come to page 15 for a moment.
I know my limitation.
yes, Mr.
Lordship, may kindly come to page 15 for a moment.
Page 15.
Yes, page 15, your Lordships, is the letter written to the head of the branch by one Basant Kumar Jena, PC CBI. He has left one thing, your Lordships. After I met with Vrindavan Parida and such, they told that they are doing bailer work in Bhubaneswar court. They do not know Abhishek Singh Chauhan and they are working under Sri Das, advocate of Bhubaneswar court. I don't know why he did not read it or left it deliberately. They are working under Mr. Das, advocate for Bhubaneswar court.
Mr. Pradhan, if you want to controvert it in the manner in accordance with law or give the two fresh bailers, it is up to you. Now the report has come this. If your bailers are disputing, just file an affidavit. Now then the ball will be in their court to say in the which cases they have taken the you on bail.
Yes, I am personally verified. I asked them in.
File an affidavit
Yes,
of
yes,
those two bailers.
I am prepared the affidavit.
It's a very
Because
simple
this
thing.
liberty is
Once you
granted.
give it, then the copy will be served
Sure.
on Mr. Naik, and he has to reply that which cases are those 10 to Lekon. As for the order dated 12/7/2024, the London Council for the Special Public Prosecutor has filed counter affidavit by one Ranu Chaudhary, Deputy Superintendent of Police, CBI SCB Bhubaneswar, and in relating to the genuineness of the bailers, it is mentioned that the two local sureties, namely Brundavan Parida and Chabindra Panda, whose names and documents were furnished by the London Council for the state, for the petitioner for verification, it was ascertained that those two bailers are professional bailers and doing the same since 10 to 12 years in the London courts at Bhubaneswar. Mr. Pradhan Land Counsel for the petitioner, however, submits that the two bailers are present in this court today, and he has received the instruction that till today they have not taken any accused in any case bail as surety, and he intends to file an affidavit to that effect. So we'll take up this matter next week.
Yes, yes.
Put up this matter on 26th of July 2024. Let an affidavit in that respect be filed, serving copy
By
on
Monday.
the London Council Special Public Prosecutor by 22nd of July 2024. Mr. Parija, any matter? Okay.
What's a free copy of the order may be provided?
Free copy of the order.
Item number 24.
May I please, Your Lordship? Lordship, item number 24 is permitted to withdraw, Your Lordship. Now already been convicted.
Mr. V.R. Das, Vishwaranjan Das, Land Council, appearing through virtual High Court on Ganjam at Barampur, 6 permission to withdraw this BLAPL, disposed of as withdrawn. Yes.
110 item also same.
Huh?
Item 110 also
Same.
yes.
Also you want to withdraw? the same order in item number
110.
110. Just a minute. 110, it is BLAPL number 978 of 2024.
And 726.
The BLAPL number 726 of 2024, right? Okay. Disposed of as withdrawn.
Item number 25.
Permitted to withdraw.
Mr. Pandal and counsel appearing for the petitioner seeks permission to withdraw the bail application disposed of as withdrawn. Yes.
Item number 26.
May I plus last occasion, my lord, status report was called for. The flag C made.
Mentioned that out of 60 charge sheet witnesses, 11 witnesses have been examined. And non-bailable warrant of arrest has been issued for production of 2 accused. So that is the position. You
Custodian 6/9/2020. Maybe my lord, I lost may consider.
Just a minute. 26 BLAPL 2752 of 23. What is the custody date you said?
6/9/2020, madam.
6/9
2020, madam.
2020 aguru interim bail jainanti. And how many times your bail application was rejected?
Once, madam. Once, madam.
In which case?
BLAPL number 2555 of 2021, disposed of 25/3/2022.
That was disposed of as withdrawn.
Yes, madam. In this is 49 active persons are there.
And under what offenses charge sheet has been submitted?
Charge sheet submitted. And under section 147,
Yes.
148, 302, 307, 120B, 353, 149 of the IPC, read with section 20B2C, 25,
20B2C.
again, 25, 27A, 29 of the NDPS.
27, 29.
Yes, ma'am. Prosecution case, madam, 49 active persons.
Yes.
49 active persons. The IAC madam got information that persons were madam transporting the contraband ganja.
Yeah.
Thereafter, they raid and during course of tussle, one homeguard was died. And this is the case.
What role has been attributed against you?
Particularly, no specific role against all, my lord, that all have assault.
And the witnesses who have been examined so far, 11 witnesses, what they have stated against you?
Deposition copy I have not.
The copy not served. The deposition copy.
No, I have not obtained.
Give the copies to the State Council.
Yes. Next week I will.
The period status report dated 12/7/2024 furnished by the London Trial Court, from which it reveals that out of 60 charge sheet witnesses, 11 witnesses have already been examined. The London Counsel for the petitioner seeks permission to pray for an adjournment till next week to produce the certified copy of deposition of those witnesses, giving copies thereof to the London Counsel for the state. Put up this matter on 26th,
yes,
26th July 2024. Yes.
Item number 27.
Mr. Biplab Kumar Das. Not there. Okay, pass over.
Item number 28.
Your Lordship, item 20, I'm praying for a Passover, Your Lordship.
Item number 29.
My lord may kindly see the order dated 5/7/24.
So, you supplied the
Yes, my lord,
documents of the fresh bailer.
on the same day I have supplied.
Yes, Mr.
Yes, my lord.
Gopinath Naik. Found documents are genuine. আরোটা কি যেটা
আরোটা হচ্ছে my lord দেবদত্ত সিং। No, I'm sorry, my lord. আরোটা হচ্ছে
মিস্টার ত্রিপাঠী
উদয়চন্দ্র নায়ক।
Yes.
ঠিক সে দেখুন তার না লেখিও পড়ি
Uday Chandra Naik.
উদয়চন্দ্র
Naik.
Naik. And this man belongs to which district?
My lord, state of Bihar.
State of Bihar. So you are in custody since when?
My lord, I'm in custody since 31/7/2020. And your lordship has noted, as per the status report dated 2/2/24, out of 26 witnesses, 4 witnesses have been examined.
কোডি মেনশন করছি
My lord, order dated 2/2/2024.
হ্যাঁ okay. And address verification has been made.
No.
My lord, they could not find out. That's why your lordship directed that you bailer দিয়ন্তু।
Okay. For the Learned Counsel for the petitioner and counsel for the state. You have never been earlier released on interim bail.
No. আমি তো কেবল বলছি। No.
Mr. Bose Land Counsel appearing for the petitioner submits that the petitioner is in judicial custody since 31/7/2020
2020.
and he has been charge sheeted under section.
My lord, I have been charge sheeted under section.
Mr. Tripathi,
20B2C.
20B2C,
25, 29 NDPS.
25 and 29 of the NDPS Act. The Learned Counsel referring to the order dated 2/2/2024 submits that out of 26 charge sheet witnesses, 4 witnesses have been examined so far, as per the status report furnished by the Learned Trial Court. Though opportunity was granted to the Learned Counsel for the state to ascertain the correctness of the address furnished by the petitioner in the cause title, but he has failed to obtain the same, and accordingly the Learned Counsel for the petitioner was asked to furnish the names, documents of 2 local sureties who are interested to take the petitioner on bail. After verification by the State Council, it is found that one Uday Chandra Naik and Gopinath Naik are the 2 local sureties who are interested to take the petitioner on bail. And there is also no criminal antecedent against those bailers, and their documents are genuine. The instruction dated written instruction dated 18/7/2024 received from the IIC Mohana police station is produced by the Land Council for the state, which is taken on record. Considering the submission made by the Land Council for the respective parties, the commercial quantity of ganja seized and bar under section 37 of the NDPS Act, while not inclining to release the petitioner on bail on merit, but taking into account period of detention in judicial custody, as well as slow progress of the trial, I am inclined to release the petitioner on interim bail for a period of 3 months, subject to condition that Uday Chandra Naik and Gopinath Naik shall be the two local sureties for the petitioner, and the petitioner shall appear before the London trial court on each date when the case would be posted for trial. Yes, my lord.
Item 30.
Ma'am, my lord, I'm from the behalf of Mr. Shamanor Vishna. I will join the metro for tomorrow.
Valor verification.
Madam, have you gone through the report furnished by the IIC Chitrakonda police station? You are not audible. Miss Pandey, you are not audible.
Let's say I am audible.
Okay,
Let's say I'm not audible.
I'm just indicating to you what the IIC has reported. So you furnished the names and documents of two fresh local sureties, and those two sureties are Arjuna Gowda and Sansai Muduli. And the verification report indicates that the documents are found to be fake and the identities are not correct. No such person, Arjuna Gowda, is residing in that village, and the other surety, Sansai Muduli, is dead since 8 years. So this
Doctor,
is
I can these documents are genuine.
why are you producing such type of documents, giving the names? Is it not a wastage of court's valuable time? You are giving the
I
names
apologize.
fake bailers and
My lord, regarding the fake billers, I have no instruction. But
it
as
is not
far as
happening for the first time. Earlier it has happened, and order dated 5/7/2024 I have reflected that the documents which were furnished of those two sureties were found not to be genuine, and that is how you were those two sureties were not willing to take the petitioner as bailers. So again you are asked to furnish the names of two sureties, and this is the status.
my lord, I'm seeking for an adjournment for tomorrow or any Passover. So let me consult with my senior lordship. Either Passover or my lord, can you adjourn as my lord did.
Ms. K. Pandey, Land Council, appearing through virtual mode, appears to like this. As per order dated 5/7/2024, the inspector in charge of Chitrakonda police station has produced the verification report of the two local sureties, fresh local sureties, and it is mentioned therein that the documents of the two local sureties were found to be fake and their identities are also not correct. One of the surety, Arjuna Gowda, was not residing in that village, Ghoda Dara, and the other surety, Sansai Muduli, has expired since 8 years ago. The report is taken on record. The Learned Counsel for the petitioner seeks for an adjournment, put up this matter on 2nd of August 2024.
Item number 31.
Meet please, your lordships.
Yeah.
I have a small convenience note, my lord. For your lordship's kind consideration. My lord, on 1/7/2019, complaints were filed by the Deputy Manager of Union Bank and 3 FIRs were registered. My lordships have it, the first item, serial number 1. So FIR number RC 078, so and so, wrongful loss to 13.98 crores. Second one is 5 crores. The third one is 5.19 crores. Total is 23.07. Now, 31st December 2020, charge sheet is filed. My lords may kindly turn over the page. In all, there are 96 witnesses, 457 documents. As on date, charge not framed. Now, my dear lordships, on 16/11/2021, granted me interim bail for 6 months, subject to deposit of 50 lakhs for every month. And I deposited 1, and thereafter I surrendered because I could not deposit. Thereafter, the matter goes to the Supreme Court, and then it is said to appear before your lordships and say that whether property security can be considered. Now, I have a compilation of judgments passed by your lordships and the Supreme Court from time to time. My lords are kindly pleased. Look at the order dated 22/7/2022, which is at page 13 of this second compilation. Take a padidale. Page 13. My lords may kindly turn to page 15. My lords have page 15. It starts at page 13.
Yeah.
And at page 15, if my lords are kindly pleased to see paragraph 2 minutes.
Yeah.
Today, the learned special public prosecutor instruction submitted that the lands are recorded in the name of so-and-so and valuation of the land is sufficient to meet 2.5 crores, which was directed to be deposited by this court on 5 equal installments and so every month as per the order dated so-and-so. The learned public prosecutor instructions from IO does not dispute such aspect. Considering the submissions made by the learned counsel for the respective parties, keeping in view the aforesaid order passed by the Honorable Supreme Court on so-and-so and the instructions obtained by the learned special public prosecutor dated so-and-so is modified to the extent that instead of filing an undertaking before the trial court, learned trial court to the effect that the petitioner shall deposit so-and-so in 5 equal installments of 50 lakhs each every month. If Kesa Pradhan files surety bond and produces the original document, that is record of rights and EC, which have been annexed as so-and-so to the memo dated so-and-so filed before this court and verified by the learned special prosecutor, same shall be accepted. Petitioner shall be released on interim bail for the remaining period as per the order dated so-and-so. Now, my lord, thereafter, if my lords kindly turns to page 17. There is an order at page 18 where this surrender after 6 months was till further orders. And my lord may kindly see now page 19.
Yes.
The respondents are yet to enter appearance, awaiting the same, keeping in view of the fact that this court, through the order dated so and so state surrender of the petitioners herein, the benefit shall inure to the petitioner till bail application is considered and disposed of with High Court. Now, my lord, thereafter, there is another order at page 23. 23. It starts at 24. Dr. So-and-so learned senior counsel, my lordship have it, page 24. Senior counsel for the petitioner submits that due to incorrect instructions given by the learned counsel appearing for the petitioner before the High Court of Orissa to the effect that an application shall be moved before this court for correction in the order passed on so-and-so. The petitioner has withdrawn the power of attorney unless not relevant. In the meantime, due to absence of no objection certificate from the previous counsel, none appear on behalf of the petitioner, resulting in dismissal of the bail application. It is submitted that steps have been taken to move an application for restoration of the bail. A request for list week 4 weeks after, in view of the statement made of an interim protection granted, continued to operate till the disposal of the bail application and restoration. And my lords, at page 25, your lordships are pleased to restore it. All the three. So we are now, lordship may see the last order is at page 28. We are informed by Dr. Guru Swami, learned senior counsel, appearing for the petitioner that the bail application that was moved by the petitioner before the High Court was dismissed for non-prosecution has been restored on his moving an application for restoration. Same is now pending consideration. The said factual position is not disputed. In view of the aforesaid position, it is directed that the interim protection granted by the petitioner in the present petition shall continue to operate in his favor till bail applications moved by him are disposed of on merits. SLP is dismissed. So now we are today, my lord, before your lordships, considering the bail application on merits. So my submission is, my lords, the entire amount has been already secured. Now 96 witnesses are there. 457 documents are there.
Secured means what is the
by form of security? That is what your lordships had initially said, that the whole loan amount, the amount of loan, lordship, just give me a minute, my lords. That note I have given to you, lordships, first, my lords. There's a 2-page note. If my lords are kindly pleased to come to page 4. Yes. If lordship may see, the following submissions are made on behalf of the petitioner. Yes. Then an amount of 23.07 crores was outstanding as per the bank. Total amount secured by way of property security amounts to rupees so and so. The entire amount alleged to have been misappropriated has been secured. Because originally your lordship said cash, and then it was converted to property. Now then I say, my lord, 68 days, kindly see serial number 2. Ever since the petitioner was released on bail, because your lordships had said you will attend on each date. So there have been 68 hearings, 68 postings, and each day I was there in court. Pertinent to know, no application seeking exemption has ever filed, but before the trial court, it is next fixed to 26/7. Now trial is at the nascent stage. 96 witnesses, 457 documents are to be proved. And I have not violated any of the conditions.
96 witnesses means
in all the 3 FIRs.
Total.
Again. And my lords are kindly pleased to see one more page. Kindly see page 8 of that compilation I've given of the different orders. I've given a compilation like this. Now my lords may kindly come to page 8 of that. Kindly see, my lords, page 9, Roman 3. These were the conditions. First condition was, I will not leave the territorial jurisdiction of the trial court without permission. Petitioner shall not neither try to come in contact with any prosecution witness or tamper with the prosecution evidence in any manner, nor he shall make any threat or inducement to any witness acquainted with the facts of the case so as to dissuade him from doing disclosing. Petitioner shall surrender his passport if possessed by him during trial. If he does not possess passport, he shall file an affidavit before the trial court to that effect. Shall personally appear before the trial court on all dates. So all this has been duly complied with the petition. So my submission to your lordship is this. A, the amount is secured. B, charges are yet to be framed. Large number of witnesses, large number of documents. And your lordships have consistently held, my lords, that in such a case, in view of Article 21, bail should be granted.
Where have you stated that charge has not yet been framed?
My lord, I have said so in my convenience note. If your lordships want, I'll file an appeal.
No, where have you stated?
In that convenience note, my lord. They're not there. No, which one, sir? Is it? Have you said in the charge not framed?
Because the status report was not.
Yes.
Status report. Status report is there. Okay, let us see that status report.
Yes.
Charge sheet filed against one so. In this case, accused persons Ashwini Patra have been released on bail. Now the case is as a supply of police. You are right.
Yes.
So this is relation to TR case number 7 of 2021. TR means which FIR relates to TR number? Acha, FIR number RC 9A. Okay, this one.
There is one 7A, 8A, 9A.
This is TR 7 of 2021. Then
7, 8, 9. In touch.
5. It all 5 ke the 7, 5, 8. No. Okay. Come to that 541, 542, and 543 in the serial advantage. 541 or 541. Okay, Mr. Naik.
Yes, Your Lordships.
Are you disputing that till date no charge has been framed in any of these 3 cases? That is.
That's a fact, Your Lordships. In fact, charge has not been framed.
Okay.
But Your Lordships, while disposing of the interim bail application, when it was listed, a learned senior, Your Lordships, argued about the number of witnesses, the number of exhibits. But Your Lordships, we were supposed to argue on the gravity of the offense, the conduct of the accused, what he has done, and the merits of the case as per the charge sheet. Now, Your Lordships, time and again, Your Lordships has held, and recently, Your Lordships, I was reading a Supreme Court judgment, that is civil contempt number 3 of 2021, Your Lordships. It is very necessary, Your Lordships, because twice, Your Lordships, this petitioner has made an attempt to mislead the court and take bail. If Your Lordships will allow me to proceed, I would like to explain how he was trying to time and again mislead the court, Your Lordships. A person who makes false statement before the court and makes an attempt to deceive the court interferes with the administration of justice and is guilty of contempt of court. The court not only has the inherent power, but it would be failing in its duty if the alleged contemptor is not dealt with contempt jurisdiction for abusing the process of the court, Your Lordships. Now, Lordships, my learned senior did not mention the fact that when this bail application, Your Lordships, was pending, he filed another bail application, Your Lordships, that is bail application number 11625 of 2021. When this bail application was pending, Your Lordships.
541 of 2021.
Your Lordships, while the 5421 was pending,
yes,
he filed another bail application, that is 11625 of 2021, in which he had given a certificate, which is a false certificate, that the bail application were disposed by Your Lordships on 16/11/2021, Your Lordships.
Where is that bail application? Jota subsequent the file is really taro order sheet kind, but taro what is that number you said?
Your Lordship, the junior of the bail application was 11625 of 2021.
11652.
11625.
Acha 625 of 20.
Which was withdrawn, Your Lordships. which was subsequently withdrawn, but he should have, but he gave a false certificate there that your lordships has already disposed of the bail application on 16/11/2021.
Okay.
So when this bail application was pending, your lordships, he filed another bail application with same facts, same cause of action, same averments.
This particular bail application was disposed of when? This 541, let us say.
541 was not disposed of, your lordships. It was pending. Your lordships had disposed of only the interim bail application.
Okay.
It was pending.
Interim bail application was disposed of when? That is okay. That is perhaps on 22/7/2022.
Yes, if it was disposed of on 22/7/2022,
yes,
then he has given a certificate, your lordships. He has given a certificate, your lordships, that it was disposed of on 16/11/2021.
No, what is that, Mr. Nayak? I just want to see that that cause title of that BLAPL.
Uma Shankar Patra versus Republic of India. I think junior of the learned senior counsel must be having that bail application because he has filed it. 11625 of 2021.
Any such application was filed, Mr.
Actually, he doesn't know. He's been appointed. He's been engaged in this. If your lordship call it on the next Friday, we'll check up and get back.
Yes. Please.
And well, that is in relation to this 541. Whether any such application was filed for 542 or 543.
Your lordship, 3 bail applications are filed. I am reading the certificate. The matter out of which bail application is also connected with bail application number 541, 542 and 543, disposed of on 16/11/2021. This is contemptuous in nature, your lordships. How can he lie?
That is 11,625, you said. 2021.
Yes. I think, your lordships, if I exactly remember the date, lordships had disposed it on 8/7/2022. It was disposed of as withdrawn.
It would be better if that application is, let me place that application itself.
Yes, your lordships.
Okay.
And also, your lordship, kindly see what are the commonalities between the two petitions, because it's identically the same.
Just a minute. So, hard Mr. Ashok Parijal and senior advocate appearing for the petitioner. It is likhive BLAPL number 541 of 2021. Also in BLAPL number 542 of 21 and BLAPL number 543 of 2021. The Land Council files the convenience note and convenience compilation which are taken on record, copy of which has been served on Mr. Sarthak Naik, Land Special Public Prosecutor appearing for the Republic of India, CBI. During course of the hearing of the bail application, Mr. Naik submitted that while these 3 bail applications were sub judice before this court, the petitioner filed another bail application, that is BLAPL number 11625 of 2021, wherein a wrong statement has been made that the earlier bail applications, that is BLAPL number 541 of 2021, 542 of 2021 and 543 of 2021 have been disposed of by order dated
16/11/2021.
16/11,
your lordships.
16/11/2021.
Instead of wrong statement, your lordship indicate wrong certificate.
Sure, wrong certificate. Wrong certificate has been given. Stop. When this court asks the Land Council for the respective parties to produce the copy of such petition, the Land Council submitted that at present they are not having such copies. Let the registry place this matter on 26th of July.
Can be week thereafter. 26th, I am personal difficulty.
On 2nd, Mr.
Yes.
on 2nd of August 2024 with BLAPL number 11625 of 2021, which is stated to have already been disposed of as withdrawn, na?
As withdrawn, Your Lordships.
As withdrawn. All right. Great.
Pardon, my lord, in the same item, BLPL 7532.
Your Lordship, that order dated 16/11/2021.
Which one?
Your Lordship, the order which was referring 16/11/2021 in this matter, Your Lordships.
Yes.
Website has all the orders except this order that has not been uploaded. Lordship, if that order can be obtained, I can also see
Let the
instructions.
file come on 2nd. If it has been inadvertently not uploaded, I will ask the registry to upload the order. Okay.
Pardon, my lord, in the item 31,
Yes.
yes, item 31, for the petitioner Ashwin Kumar Patra.
Yes.
On that last occasion, my lord, status report was called for. In that case, BLPL 7532.
Where is Mr. Naik? He is also there.
Your Lordship, may kindly give me 5 minutes. I'll ask Mr. Naik to join, Your Lordship. Just one
another
pass
matter
over.
is there.
Yes, Your Lordship. The
Okay.
first connected matter.
All right. Yes. So this order is passed in respect of these 3 BLAPL, right? Now, Arata say Mr. Naik link dela pare join kala pare take up kara jiye. Please wait, Mr.
Yes, yes.
Yes.
Item number 32.
Please.
Huh? Subin. 31?
Item 31, my lords. It is bad.
No, whether Mr. Naik is there.
Sir, kindly unmute.
Mr. Sarthak Naik.
Mr. Naik had just joined. I'm just informing.
All the other matters, let him appear. Let him appear when take up.
Item number 33.
May I please, your lordship?
Yeah.
Your lordship, in this case, my lord had called for the status report with regard to whether the petitioner has surrendered on time after being released on interim bail, my lord.
Yes, the accused statement has already been recorded and now it is case posted to defense evidence. Look on the BLAPL number 7883 of 2023. Peruse the status report submitted by the London Trial Court dated 18/7/24. 18/7/24.
Yesterday.
Is yesterday's report, from which it appears that accused statement has already been recorded and the case is posted to 27/2024 for defense evidence. In view of the stage of the trial, I am not inclined to release the petitioner on bail. Stands dismissed. Yes, Mr. Naik,
Yes, ma'am. Yes,
Mr.
Lordship.
South is moving that other application which is left out in that item number 31.
Yes,
That is
Lordship.
Ashwini Kumar Patro.
Yes, your lordships.
And last occasion, a status report was called for from the court below.
The report has come, Mr. Raut, and the report indicates that charge sheet has been submitted on 4/1/21 against 6 accused persons, and cognizance was taken, and the accused persons except accused Ashwini Patro have been released on bail. Now the case is posted to 26/7/24 for supply of police papers to the accused. That means the trial has not commenced.
Yes, my lord.
Okay. So you are in custody since when?
Custody, my lord, from the date of arrest.
31st December 2021.
31st December 2021. So it is virtually 2.5 years you are there in custody. You are a local man, or
Yes, my lord.
so Mr.
31/12/2020, your lordships.
Oh, 20.
48.
So it is 3/1. So it's a local man. Yes, Mr. Naik, what is your objection if he is enlarged on interim bail for 3 months? Because 3.5 years and police paper is to be supplied. So it is the same case where the Mr. Parija was mentioning that 91 witnesses are there and some 400.
Yes, lordship. He's a co-accused.
All right. Heard the London Counsel for the petitioner, London Counsel for the state. The London Counsel for the petitioner submitted that the petitioner is in judicial custody since 31/12. 2020, and thus he has undergone, he has remained in custody for more than 3.5 years. As per the order dated 5/7/2024, the status report was called for from the London Trial Court, and same has been received, which indicates that the case is now posted to 26/7/2024 for supply of police papers to the accused persons. After hearing the London counsel for both the parties and taking into account the period of detention of the petitioner in judicial custody, and since the petitioner is a local man and the trial is yet to be commenced, in view of the nature and gravity of the accusation, while not inclining to release the petitioner on bail on merit, but in view of the period of detention, he is enlarged on interim bail for a period of 3 months. While on interim bail, the petitioner shall appear before the London Trial Court on each date the case would be posted for trial. He shall not indulge in any criminal activities, shall not try to come in contact with any prosecution witnesses. Violation of any terms and condition shall entail cancellation of bail, shall not leave shall not leave the state of Orissa without seeking prior permission of the London Trial Court.
Lordship, may write only one line opposition that I oppose to the
London Council for the Mr. Nayak, Land Council for the state, oppose the prayer for bail mainly on the ground of nature and gravity of the accusation. All right.
Item number 34.
Ma'am, last occasion, your lordship directed to file comprehensive affidavit.
Which one? 34.
Ma'am.
Just a minute. How many petitioners are there?
One petitioner.
Jagabandhu Vaitharu.
Ma'am.
What are the offenses here?
21C.
Acha. Earlier bail application was rejected.
And your lordship directed to renew prayer after.
Okay, first tell us when he was taken into custody.
Was taken in custody 11/10/2022.
Huh?
11/10/2022.
So when your first bail application was rejected?
9/1/2023.
No. Have you got the copy of that order? Acha, 7. No, this is 7947 of 2023 is this one.
The present bail application.
Acha.
An earlier bail application was 4788
of 2022.
My lord.
So that was disposed of on 9/1/23.
My lord.
And this court was not inclined to grant you bail because of that commercial quantity of brown sugar, and taking into account the bar under section 37, however, directed the London Trial Court to expedite the framing of the charge and conclude the trial within a period of 6 months from the date of framing of the charge. So what is the position now? Status report was called for?
My lord.
Acha, कौन the status report देखेले? 8 witnesses have been examined so far out of 19, and remaining 8 witnesses have been declined. So 8 decline हेले, 8 examine हेगले, 16टा सरी गला, बाकी आउ 3टा रहिले. 3 witnesses including the IO are to be examined in this case. Summons have been issued and the date of trial is posted to 3/8/24. That
On
is the
several occasions, my lord, I was called for evidence, but he has not turned up.
ए केस तो चालीची आउ दी 3टा साक्षी अछन सर जिवे आपणकर ନାଁରେ କେତେଟି କ୍ରିମିନାଲ କେସ୍ ଅଛି?
ଦିଟା ମାଇଲର।
ଦୁଇଟା habitual offenders similar cases
ଆଚ୍ଛା।
NDPS
ଆଉ କେସ୍ ଅଛି?
ନାଇଁ ଦିଟା ଅଛି ଦିଟା ଯାକ
ଦିଟା
NDPS
below commercial quantity.
maybe
NDPS ରେ ଇଏ ବାହାରିଲେ ଆଉ କଣ ହବ?
ନାଇଁ।
If you have got criminal antecedent similar antecedent in NDPS card, so why bail will be granted? It is right that now I'm directing to conclude it within 2-3 months, let us say 11. The Learned Counsel for the petitioner submitted that the petitioner was taken into judicial custody on 11/10/2022 when he approached this court first time for bail in BLAPL number 4788 of 2022 as per order dated 9/1/2023, while not inclining to release the petitioner on bail. This court directed the Learned Trial Court to expedite the framing of the charge and to conclude the trial within a period of 6 months from the date of framing of the charge. And the petitioner was also given liberty to renew the prayer for bail if the trial is not concluded within the said period. Status report dated 10/7/2024 furnished by the Learned Trial Court indicates that out of 19 charge sheet witnesses, 8 witnesses have been examined, 8 have been declined, and the case is posted for the examination of the investigating officer. The Learned Counsel for the petitioner submit that in spite of repeated summons, the investigating officers are not appearing to give their evidence. The Learned Counsel for the state, however, submitted that there is a criminal antecedent against the petitioner, which is also under NDPS Act. In view of the submission made by the Learned Counsel for the respective parties, while not inclining to release the petitioner on bail, the Learned Trial Court is directed to record the evidence of investigating officer through virtual mode, and if they have been transferred to other districts in the meantime, and try to conclude the trial within a period of 3 months from the date of examination of the from the date of closure of the prosecution witnesses. Copy of the order be communicated to the Learned Trial Court.
Item number 35.
Yes.
That time I directed to
Item number 62.
My lord, I'll first place, my lord, asked the last order that my lord was passed. It was dated 10/7/2023 when it was rejected.
Yes, so it was rejected. Why again?
Yes. And the order prior to that is the order dated 14/3, my lord, may kindly peruse.
No.
Same bail application.
No, this 4422.
Yes, my lord.
That is in respect of both the petition. In that, it's a common order was passed.
Yes.
And 4422 and 3884 were disposed of.
Yes, my lord.
So that was on 10/7/23.
Yes, my lord. And my lord had passed an order earlier to that in 4422 dated 14/3, which has been reflected by my lord in internal page 5 of the previous order. That regarding payment of 15 lakhs. Deposit of 15 lakhs. And on deposit, my lord, to consider the bail amount. That was not deposited.
No, 14/3. So where is that order dated 14/3?
Yes, madam.
Oh, that was passed in respect of that lady. Yes.
Both, my lord, I think, not lady, both, I think. Both, my lord.
Both?
Yes, yes. I think both were.
No.
My lord, were considered only the lady, my lord. I don't know, my lord.
BLAPL number 4422 of 2022. Pallavi Misra alias Pallavi Hota. Peruse the affidavit filed by the father-in-law of the petitioner Pallavi Misra. Let 15 lakhs be deposited before land and presiding officer, so and so.
Yes, sir.
So, yes.
My lord, I have given that judgment, my lord. I'll go to the judgment later, my lord. Ramesh's judgment categorically says, my lord, that deposit cannot be a precondition for granting bail, my lord. That judgment, my lord, I have given to my lord, my lord. Before I go into that, my lord, may I just take, my lord, this.
No, against my order.
My lord.
You have approved the Honorable Supreme
No,
Court?
no, my lord. I have come before my lord saying that, my lord, may kindly consider doing away with that condition.
You have filed an interim application?
No interim application.
Then?
Final application is filed.
Yeah.
Final application is filed saying that, my lord, this order runs contrary to the judgments of the Supreme Court earlier and confirmed by.
Then why did you challenge it in the Supreme Court? If it runs contrary.
My lord, I must come back to my lord, my lord.
Yes.
I must come back to my lord.
No. Unless there is a change in the circumstances, I rejected it on
1 year back,
10/7/23.
1 year back.
Yes.
1 year itself, my lord, is
So
wrong.
what is the change in the
The
meantime?
fact, my lord, I'll take my lord to the deposition, but before that, my lord, I can always come before my lords to beseech my lord's indulgence.
No, you
for
say
the
that it is against the order of the. We challenge it in the.
No, my lord can also reconsider, my
No,
lord.
it's
My lord
bail
can reconsider.
application. It can be considered only on change in the circumstances. It is not a review application that I will consider
No,
one decision and.
my lord, res judicata strictly, my lord, doesn't apply, my lord. I can always come more time than one before my lord and pray for my lord indulgence. And my lord have done that in other cases also. My lord have reduced, given property surety also, my lord, in other cases, various other cases.
No, that opportunity was given then, that to Pallavi.
Yes, my lord.
After hearing the Mr.
Yes, my lord, but
you
Pallavi
did not agree at that point of
no,
time.
that, my lord, fortunately, father-in-law does. Father-in-law swears an affidavit, my lord. They are oblivious, they are in custody, and they are not in a position to pay the money. That is my prayer now, my lord.
So your submission is now that in view of the decision of the Honorable Supreme Court, the bail application.
Apart from that, my lord,
Yeah.
I am craving, my lord, indulgence in view of the fact that I am not able to pay, my lord, and regarding my encarcation for further period of 1 year more than 1 year, and the fact that 5 witnesses have been examined, and the fact that on a bare reading of those evidences, it is abundantly clear that the OPID Act doesn't apply. Others are all, my lord, small petty offences, my lord. And I'll also demonstrate to my lord that the agreement, there is no agreement, there is no scheme. And that is also reflected in the depositions of the 5.
Those things are, if you can challenge the charge, framing of the charge, you have not challenged.
My lord, I bow down to all that, my lord. But I'm only saying, my lord, even
in a bail application, if I give a finding, Mr. Das, that the ingredients of the offense under Section 6 of the OPID Act are not attracted,
no, my lord,
even though he has not challenged the order of framing charge, then what would be its effect on the land and trial court who is in the session over the matter?
My lord, what happens, my lord, if in OPID, when in narcotics, my lord,
you had got the stays. You could have filed the application for discharge then and there. You did not do. Even if after framing of the charge, if you say that no, that is illegal, you could have challenged it. Now you are facing the trial, cross-examining that. In a bail application, how
no, my lord,
I will observe that.
Not observe, my lord. I'm only saying that on the my lord, when cases even of murder, my lord, when my lord sees that this many witnesses have been examined, none of the witnesses have stated this, or the primary witness doesn't state this, my lord, have reconsidered bail.
And what about that decision which you are pressing?
Yes. No, my lord. Before that, my lord, may I just take my lord to deposition? Yes, deposition on the judgment, my lord. Should I take my lord to the factual aspect then and take my lord to the judgment later?
No, the decisions, that is only an offense under 420.
No, my lord.
The offense, the decision which you cited,
my lord,
Ramesh Kumar.
Yes, my lord.
It is under 420 of the IPC. It is not under that act which was specially enacted for the purpose of.
No, my lord, kindly, I'll read my lord the judgment, page 16 onwards. In any case, my lord, the judgment is abundantly clear. Not as if it specifies OPID or anything, my lord. It is generic. My lord, may kindly take from paragraph 16 onwards.
Yes, paragraph
16 onwards, my lord. The legality of the impugned condition.
16.
Paragraph 16, 1-6, my lord.
1-6 of Ramesh Kumar.
Yes, my lord.
Ramesh Kumar 1-6, it starts with a striking feature of the case.
This is SCC, my lord. My lord has SCC or my lord has something else?
No, I don't know what is there.
SCC, I have given my lord this. Yes, my lord can
Yes.
pass on the SCC.
No, it's all right. If it is there.
I have given SCC judgment.
Just let.
We have given the list of citations also, no?
Last week we have submitted.
Yes, we have given that to the respondents also, the prosecution. So it may not be, it may not have come. My lord had seen, had given it, my lord had also seen it and then directed me to supply to them.
Which paragraph?
Paragraph 16 onwards.
A striking feature.
The legality of the impugned order.
Yes.
The legality of the impugned order is what we are tasked to examine and decide. It would be appropriate at this stage to note that precedents, precedents in the field governing the discretion of courts to grant anticipatory bail.
Leave that, please.
Yes.
Yes.
We start with SIBA.
Where this proposition has been laid
Yes,
down.
yes. This is the very proposition.
That in an economic offense,
Yes,
under
yes.
no circumstances,
Yes.
the court can ask for
Yes,
depositing the fine.
Yes,
That.
Yes, yes. My lord, all the judgments have been, all the judgments that time have been.
Principle of 438. We are not here, and it's a regular bail application. So come to the straight to that paragraph.
Yes, yes. Law regarding exercise of discretion. My lord, may kindly see the first page. This is the law that settled qua 438 and 439. Not as if it was specific to 438.
Which paragraph you are pressing?
25.
Yeah.
Law regarding discretion while granting a prayer for bail under 438 have been authoritatively laid down by this court. We cannot but disapprove the imposition of a condition of the nature under challenge, assuming that there was substance in the allegations of the complaint and the appellants either in connivance with the builder or even in absence of such a connivance has cheated the complainants in the investigation has yet to result in a charge sheet under 173 CRPC, not to speak of the alleged offences proved before the competent trial court in accordance with the settled procedure and the application of laws. Subsection 1 of 438 does not empower the court or the court of sessions to impose any condition while making the direction under the subsection 1 and fit and the light of the facts of the particular case. However, a reading of the precedents laid down by this court referred to above make the position clear that the condition to be imposed must not be onerous, unreasonable or excessive. In the context of a grant of bail, all such conditions will facilitate the appearance of the court before the investigating officer or court, unhindered by the completion of investigation, trial, or safety of the or assume relevance. However, inclusion of the condition of payment of money by the appellant for bail tends to create an impression that the bail could not be secured, could be secured by depositing money alleged to have been cheated. This really is not the purpose of or intent of the provision of the grant of bail. We, however, are not to be understood that what to have laid down that in no case willingness or payment of deposit of the accused persons where the allegations of misappropriation public money by the accused leveled and the accused while seeking indulgence of the court to have his liberty secured or restored volunteers on account of what the whole part of the public money alleged to have been misappropriated, and it would be open for the court concerned to consider whether in the larger public interest the money misappropriated should be allowed to be deposited before the trial court or before the court for anticipatory bail or bail as undertaken in the final consideration. After all, no court should be averse to putting public money back in the system if it is situation is conducive. Therefore, we are minded to think that the approach would be in the larger interest of the community. However, such an approach would not be warranted in the case of private disputes where a private party complains that the money is being involved in the offense of cheating. Turning to the facts of here, we find that the version of the FIR is that it had taken the face value amount of rupees so and so and rupees so and so. We have not been able to comprehend how the High Court had later payable amount to be this much, and the appellant's counsel well agreed to such figure. Prima facie, there appears to be some sort of calculation error. Also, prima facie, there remains some doubt regarding the conduct of the appellant in receiving checks from the complainants without there being any agreement inter se. But it may be that the High Court ought to have realized that having regard to the nature of the dispute between the parties, which is predominantly civil in nature, the process of criminal law cannot be pressed to service for settling civil disputes. Even if appellants have undertaken to make payments and they have inclined to believe that the last ditch effort to avert to losing their liberty, such undertaking could not have been weighed in the in the mind of the High Court to decide the question of grant of anticipatory bail. The test of grant of anticipatory bail is well delineated and recognized by passage of time. The High Court would not have well advised to examine whether the appellant was denied anticipatory bail on his failure to satisfy such a condition. It does seem that the submission made by the counsel for the on behalf of the appellant from the High Court that had its own effect. Although it is far from being relevant for consideration for purposes of grant of bail, it does not appear from the material on record that the complainants have instituted any suit for recovery of the money alleged to have been paid to the appellants. If at all the offense alleged to have been proved resulting in their conviction, it would not be bound to suffer the penal consequences, but despite conviction, he may not be under any obligation to repay the amount alleged to have been received by the complainant. This too is an aspect which the High Court, while exercising jurisdiction under 438, did not bear in mind. Under this circumstance, we hold that the High Court fell in grave error on the basis of an undertaking given by the appellant and imposing a payment of rupees so and so, a condition precedent for grant of bail. We are not unmindful of the fact that the High Court was led to the appellant himself order granting the imposition of the impugned condition. Hence, we are not inclined to remit the matter to the High Court in line of the approach of the High Court in Mahesh Chandra's case. We direct reconsideration of the application of pre-trial bail in its own merit in the light of the observations made as early as possible, preferably within so and so date.
So whether I rejected your bail application,
my lord,
last time,
my lord,
merely because you did not pay that amount of rupees 15 lakhs.
That was one of the conditions, my lord, for grant.
It's all right, but what is the final observation?
Final observation, my lord, final observation, my lord, is that my lord didn't grant me bail. That's
final observation, please come to the operative part.
Yes.
I have considered the nature of accusation,
Yes.
the huge amount collected from the innocent persons on the bedrock of the false assurance, since it's an economic offense which is considered grave offense and it is committed with cool calculation and deliberate design which has far-reaching impact on the society, and keeping in view the larger interest of public and state, I have am not inclined to so and so.
Yes.
So that is not that I have because I while just passing that order, I said that one point of time the such a condition was passed, but he said that he had assured to arrange the money, but that was not the ground for rejection of the bail application.
Well,
so that is the distinction.
I accept, my lord, what is falling from my lord. I am only indicating, my lord, that huge amount collected would not have been a consideration refusal of the bail, my lord. One, because of the fact that Antil's case in paragraph 66 categorically said that, my lord, in Subhash Chandra's case, they were granted in 6 months. That was, my lord, going to hundreds of crores. My lord, the Lalu Yadav, where he was convicted, my lord, he was granted bail in 6 months. And
don't compare the economic condition of those states with Odisha. Odisha people,
my lord,
as you know,
my lord wants to see the people who have invested.
No,
My lord, that's ridiculous, my lord. My lord, I'll show the agreements.
their hard-earned money they
No, my
used to invest, and with assurance that they will get return,
it's
and you
no,
are comparing with
no, my lord, it's not that way. My lord, may see the agreements. My lord, these people were rich people. It is misplaced sympathy, even, my lord, to my lord, may see the agreement. I'll send over. They have not even.
rich people. You made them poor by taking their
No,
money.
my lord, they have plenty of money. How much of money they've got back? My lord, may kindly see the agreements. The agreements. No way.
By the way, how much money you have collected from them?
According, I don't know.
As per
how
the
much
charge sheet,
charge sheet amount,
I
I
have
think
reflected
5
it.
crore something.
That is
5 crore something, my lord.
Yeah.
My lord, I accept all that, my lord. I accept. Am I for one running away from that, my lord? My lord, what happened? My lord, may kindly see the agreements, my lord. My lord, may kindly peruse the agreements. Who are these poor people, my lord? One of them, and this is one sample agreement. Investment agreement dated so and so. That second, the first party approached the second party and agreed for an investment of 5 lakhs for the following condition. The first party authorized with respect to managing the funds, invest and reinvest. Where have they, my lord? Where have they said that I have made something for a deposit, my lord? Invest and investment, cash and cash equivalents acquired, dispose of, otherwise managed on their part. They were the agent, my lord. The select, the place and orders of the dealers, brokers, my lord. It was basically a share agreement, my lord, where these people had the expertise, supposed expertise, which they accepted. Where are the poor people, my lord? It is not a case of Ponji, or it's not a case, my lord, of the Sahara. These are rich people, my lord, who have invested and got back money also. And when the going went bad because of COVID, my lord, I was arrested. They filed FIRs. I couldn't pay them for some time.
Okay.
And I can never pay them. And my lord, may kindly see, my lord, may peruse these orders. I'll give a short note. None of them, my lord, there is any scheme or any deposit. I'm supposed to be managing the money as an agent, my lord. My lord, may kindly see further. Custodian for settlement in trades, perform other acts which may be, my lord, I am essentially all the agreements, my lord, all the agreements of this type, and there is no other scheme, my lord. My lord, may kindly see. The second part will hold harmless and indemnify the first part. Paragraph 6, point number 6. My lord, they are supposed to be indemnifying me the investment they made. So wherever, my lord, is a criminal, at the worst, my lord, is a criminal breach of trust. At the worst, it's a criminal breach of contract, my lord, not even trust. It's a pure civil nature, my lord.
Okay.
These are clear from this. My lord, may kindly see the agreements are prototype. And my lord, may kindly see the depositions. The 5 depositions that are there.
Yeah.
In the year 2016, Surya Narayan Hota was residing in rent in the house of Bhagwarati so-and-so, Dhenkanal town. Well, they are all mostly people from Dhenkanal, and the other people who are there, and accused Hota working in the shipping company. My lord, he was a captain in the merchant navy. He thought that this is the bright student. He thought that this is the way he can manage people's money, and when the going was good, my lord, these people were happy. During the period of so-and-so, I have friendly relationships taking terms from Hota. Here, my lord, is a friend. So what was he keeping me as? his agent, my lord, for the purpose of dealing with his money to improve upon it and multiply it. And if it doesn't go, my lord, how do I become, how does it become case at all, my lord, criminal case at all? My lord, may kindly see. And my lord, may kindly see paragraph 2, share market business. My lord, so many people have gone pauper in share market business. And handsome interest. Handsome interest, my lord, is not there anywhere, my lord, in the agreement. When they've given money, they have not even signed a piece of paper except this agreement. Where is that handsome agreement, interest? Per month deposit of 2 lakhs and the said scheme. Where is the scheme, my lord? The scheme also is not demonstrated anywhere. Doesn't see the the color of that agreement is not even produced before the trial court. That one to get 25,000 rupees only towards interest per month. This also, my lord, is nothing in writing. Except this agreement, there is nothing else. Except word of the mouth that he told me that he'll pay me this amount of money. And there before that, my lord, he said it's a share purchase agreement, my lord. At the most, my lord, I can be a person whom we bestowed confidence. And it didn't work. Then, my lord, examination deferred. I have paid 2 lakhs only in phased manner from my account through phone pay to the accused Hota on September 2021. After payment 2 lakhs accused persons, I got interest of 20,000. Not interest, my lord. He got whatever he made money. The company took some money for the purpose of it, and that money was given to him. He had a right to invest or not invest it back with me.
All right, I will look into this evidence.
Yes, and my lord, may kindly see the other and my lord, may kindly see one of the depositions. Period 1, 17, very important, my lord. No brochure, leaflets of Pearl so-and-so services were supplied to me or regarding details of the scheme or anything. So where did I con them by giving this? Entire deposition where there is nothing, my lord, which makes out a case at all, my lord. All 5 of them. My lord, may kindly see PW4 thereafter, my lord. I'm demonstrating, my lord. I'm not going anything beyond that, my lord. PW4, my lord, may kindly see paragraph 4. On deposit of 6 lakhs in a financial scheme of the said company. There is no financial scheme at all, my lord. It is all I managing their money as their agent. And they themselves admit that. Received one, my lord, from 6 lakhs, they have received 1.71. And when they received it, going was good.
It is your submission that unless the deposit is made under a particular scheme that would not attract
yes,
the opinion.
Or I tell them, I'll give them handsome interest, my lord. My lord, which my lords have held in other cases.
See the definition of deposit.
Yes, my lord.
Is it say that it is to be made under any scheme?
Yes.
Please see that.
Yes. 6.
No, see the definition of deposit.
Yes.
In section 2B.
2B.
Where it is stated that the deposit should be made under a scheme.
Includes, my lord, that has to be done. I'll when I had addressed that, my lord, previously before, my lord. Includes and shall be deemed always to have been included in receipt of money of acceptance of valuable commodity
No,
to be
depositor definition.
My lord.
Section 2B.
Yes, my lord. Yes, I'm reading 2B. Deposit includes and shall be deemed always to have included any receipt of money or acceptance of valuable
Are you reading OPID Act section?
Yes, Orissa OPID Act.
Sir, 2B ର definition ସେଇଆ ଲେଖା ହେଇଛି?
Yeah, yes, my lord. What is the protection of interest deposited?
2B definition ଲେଖା ହେଇଛି 2B deposit means deposit of money either in one lump sum or by installment made with financial establishment for a fixed period for interest or for return of any kind or for any service.
Which? This year, this is which year, man? This is the old act. Go वर्ष की था? 16 देता है.
The definition of deposit and also the financial establishment.
Yes, my lord. Both, my lord.
Please see the.
Yes, yes. Means deposit of money either in one sum or in installments made with a financial establishment for a fixed period for interest or return or any kind of any service, my lord.
See also the financial
Yes.
establishment definition.
Means an individual or association.
So
or
financial establishment
yes.
includes one individual. Number one.
Yes.
Deposit does not mean that it should be made under a particular scheme. So the advance which is the argument which is advanced by you
my lord.
that there was no scheme, nothing of that sort. So PID Act would not be applicable. How do you meet this?
My lord, I'm only saying that in every case where money is given to a person to invest on your behalf does not make him amenable in this under sections. My lord, can you take section? My lord, 6 has to be read conjunctively with this, my lord.
Same thing. Anybody has taken it and not fulfill its commitment, not made the return, then that will attract this.
Then, my lord, everyone who takes money.
No, that will not be everyone. Because of this, there are some riders are there.
Yes, sir.
But you are taking it to, and suppose somebody a scheme is there, then only can. That means without any scheme, if somebody accepts the deposit of some persons and ultimately cheats him, does not return it, then the OPID Act would not be applicable. That is your submission, and perhaps you are going through that old book, but not having the new one where the definition is very clear.
No, my lord, all the same, my lord. I will address. I'll address that, my lord. I'll address that. I'll address that, my lord.
And how? By the way, how many witnesses are there in the charge sheet, Mr.
33 witnesses.
So why have you examined only 5 when she is in custody, or both of them are in custody for since 2022, or when the trial commenced? The trial commenced in the number of the case is city case number 4 of 22.
Yes,
and the first witness was examined on 12th April 23.
Yes.
We are in July 24. You have examined only 5 witnesses. So what is your progress?
The date of filing, there are 5 witnesses. In the meantime, either the lordship can call for a report or I will submit the.
No, it is to be. You see, for everything court cannot. You are there. It is from Cuttack you can ascertain.
Supply the latest position.
Because the PW5 evidence was recorded as it appears on 26th February 2024. Mr. Das is submitting that is the status now.
In the meantime, more than 5 months has been elapsed.
No, 5 months elapsed, but whether any witness has been examined or not?
No one has been examined. Our instruction.
Make a mention before your lordship how many witnesses have been examined.
And number 2, how do you meet this judgment which says that this type of condition should not be fixed? Have you got any contrary decision that in economic offenses the court has power also to impose that you deposit the fine amount? It is to see that the money is secure, the innocent person's money is secure before grant of bail. Find out those decisions also. Okay.
There are more than.
We can take up on 26th. Mr. He is also highlighting that there is no scheme, nothing issued by the company or that the accused person. So if any deposit is made, that would be in a private nature, suppose, and a civil dispute may be civil case maybe, but it would not attract the criminal penal provision. So these things he is highlighting.
Only civil.
So,
my lord, can my lord consider granting us interim bail?
26th will consider this London Counsel Yashovan Das, senior advocate, cites decisions of the Honorable Supreme Court in case of so and so, reported in so and so, and also filed the investment agreement which had taken on record. The Land Counsel for the petitioner highlighted that the petitioner Pallavi Misra is in judicial custody since Kebet Roylani. Pallavi.
Both are together, my lord.
7/5/2022, and Satya Ranjan Hota is in judicial custody since
same date, my lord.
Same day. Both are in custody in so and so.
No, my lord, I think petitioner present with which one?
Satyaranjan Hota 14/3.
14/3, my lord.
Kuda.
Satyaranjan Hota.
Acha, Satyaranjan Hota is 14/3/2022. Pallavi is 7/5/2020. And the first witness on behalf of the prosecution was examined on 12th April 2023, and he has instruction that till date only 5 witnesses have been examined. Out of what is the total number? 33 witnesses. And PW5 was examined on 26th February 2024, and thereafter no further witness has been examined. On behalf of the Land Counsel for the Special Counsel for the State, Mr. Bhuya, as well as Mr. Patra, submits that the matter may be taken up next week in order to obtain instruction relating to the progress of the trial. And so also the points raised by Mr. Das as appears in the ratio laid down in the case of Ramesh Kumar. So matter will be taken up at 2.
My lord, I want one submission of mine, my lord, to close today. But I am only stating one thing, my lord. As far as custodial intervention is concerned, I am not need it. They don't need it anymore.
Those things are not there. Mr. Jitendra Sahu, Land Counsel for the informant. These matters will be listed and so on, so taken up at 2 p.m. Yes.
Deep load.
You are mentioning it, but provided that you have broadly filed all those matters. Serial. After those matters are over, or time permits, I can take up serially. So call those matters. Which is the first one? 50.
Item number 50.
My lord, I am appearing from Virtual Court Baleswar. I am appearing in bail application number 10,104 of 2023. Petitioner Vidyadhar Rao.
Yes.
My lord, in this case, I am in custody since 10/4/2021. Earlier, my bail petition was disposed on the basis upon the statement of one Karya Singh. And now the Karya Singh has already been deposed before the court as PW5. And the deposition copy
Your earlier bail application number is?
Number is 11,510 2022 11,510 of 2022
Eyewitness account of one Kalia Singh was referred to by the London Council for the State, and it was observed that that prima facie establishes the complicity of the petitioner.
Kalia Singh has already been examined. I filed the deposition copy on the previous day. PW 5 Kalia Singh examined his, and he has not stated anything.
He has not supported the prosecution case.
My lord.
Who else are there apart from that Kalia Singh? Is there any witness who has stated about the assault on the deceased?
No. Except Kalia Singh, no one, not a single witness.
But I'm putting a question to the London Council for the State. Have patience, yes.
Statement of Kalia Singh hostile man.
Yes.
Another two eyewitnesses in this case, Sheikh Mamin and Sunil Mandal, who has not stated against the Vidyapata, the present petition.
Who are they? Sheikh
Mamin.
Spelling पहले?
S.K. Sheikh. M-A-M-I-N. Mamin.
M-A-N-I-N. Okay, Manin. हाँ. How would you get? Sunil Mandal. They are also the eyewitnesses to the occurrence. But they have not implicated the present petitioner.
No, why not?
Who is anybody appearing for the informant?
No. I am connected matters here.
Heard Mr. Vishwaranjan Naik, Land Council, appearing through virtual High Court, Balashore. He submits that the petitioner is in judicial custody since 10/4/2021. And last time when the petitioner approached this court for bail in BLAPL number 11510 of 2022, as per order dated 12/4/2023, the bail application was rejected, taking into account the eyewitness, the statement of the eyewitness, namely Kalia Singh. It is submitted that in the meantime, the said Kalia Singh has been examined in the trial court as PW5, and he has not supported the prosecution case and declared hostile. And in view of the change in the circumstances, the bail application may be favorably considered. The London Council for the State, after going through the case record, submitted that apart from Kalia Singh, there are two other eyewitnesses to the occurrence, namely S.K. Manin and Sunil Mandal, but they have not stated anything against the petitioner Vidyadhar Raut. Considering the submission made by the London Council for the respective parties, the change in the circumstances after rejection of the earlier bail application, since eyewitness Kalia Singh has not supported the prosecution case and the other two eyewitnesses have not implicated the petitioner, taking into account the period of detention of the petitioner in judicial custody, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail, subject to condition that he shall appear before the London trial court on each date to which the case is posted and shall not try to come in contact with any prosecution witnesses, not to tamper with the evidence, and not indulge in any criminal activities, violation of any terms and condition shall entail cancellation of bail allowed. Yes, next. Next item.
Second case, my lord, that VLPL 4007, my lords.
Yeah.
I am there, my lords. Here, my lord, the petitioner is in custody since 15/4/2021, my lords. And here, my lords, FIR is against unknown persons, my lord. And there are.
It is another case or same case?
Arising out of same, my lord.
So, what is your implication?
implication, my lords, eyewitness account, and
No, this Kalia Singh has turned hostile.
Kalia Singh, another is Sujay Kumar Das, that I have annexed also in my bail petition.
No, these two witnesses he has stated, Madam stated, Sheikh Manin and Sunil Mandal.
Yes.
Have they implicated you?
My lords, this Kalia Singh in 161 had implicated.
Kalia Singh forget, now he has given the evidence.
Sujay Das also, my lord, he had implicated eyewitness, my lord. That is, I have annexed also the deposition at page 19 of my bail.
Sujay Das?
Yes, he was the trawler driver, Sujay Kumar Das.
He has been examined as PW?
6, my lord.
6, not supported?
Yes, page 19 I have given the deposition copy.
Okay, then how ki rahle?
Sheikh Mamin, Sunil Mandal.
Sheikh Manin ଆଉ Sunil Mandal ସେମାନେ କଣ କହିଲେ Sheikh Imran ବିଷୟରେ?
Sheikh Mamin, he has, my lord, declined, my lord. I have the certified copy. He has declined, my lord.
No, he was declined in not by the prosecution.
Yes.
Prosecution.
So, my lord, earlier, my lord, I had.
What about Sunil Mandal?
Sunil Mandal, he has implicated, my lord, in the 161, my lord.
But not examined in the trial court.
Yes, Sunil Mandal, another Prakash Sen, not examined. But the person, my lord, the eyewitnesses, this Sunil Mandal and Prakash Sen, and they have.
What they have stated against you, Sheikh Imran?
Yes, I am placing.
Sunil Mandal.
Yes, I am placing.
Your bail application was also earlier rejected.
Earlier rejected, and Honorable Court, I am passing, my lord, copies. Honorable Court said, my lord, that examination of material witnesses had given liberty. As in twice I had before your lords. That ELAPL, that is 3103. Another is, my lord, 11253. After this, my lord, disposal of this DLAPL 3103 of 2023, this PW5, Kalia Singh and Sujay Das, they were examined. They were examined on.
All right.
Yes. So, per the statement, my lord.
What about Sunil Mandal?
Yes, I am placing.
What role he has attributed against Sheikh Imran?
Yes, Sunil Mandal, I am placing the 161, my lords. कोड़ा पता काम विजय प्रधान इज डिसीज मिलर विजय प्रधान ड्राइवर काम करे उक्त ट्रॉलर रे तो ट्रॉलर रजिस्टर्ड नंबर एते विजय प्रधान को ट्रॉलर रे काम करथिवार फिशिंग लेबर गुणाकार बार प्रकाश सेन अन्य माने ट्रॉलर धरि आसी मिटू पात्रंक जेटी पाखरे पहुंचिलु जेटी प्लेटफॉर्म ऊपर माछ बाहर कलु मालिक विजय बाबू माछ भोजन जगह बसतिया बेले हठात बालेश्वर दिगार मैदान शेख जापान उर्फ शेख इमरान पिटिशन मिलर्स चांदीपुर नुआपुर शेख इसाक बलरामगढ़ी मिर्जापुर कटी बाबू ओरफ नन ओरफ शेख रफिक रवि बारिक राजू महालिक सारगां हर्षपुरा गाँव बिजू दास नुआ बजार विश्वजीत षंड भास्करगंज पंडू इज मिलट आशीष श्रीचंदन that has he has also been released by this honorable court. I will place that judgment. पंडू मिर्जापुर गोरा सिंह शेख अहमद
कौन कले
करी पहुंची 500 जन फाते सेठारे पहुंचिले सेमानक मध्यरु जापानी इसाक पंडू कटिअबू पिस्तल धरथिले ओ अन्य माने तेलेंगा कोटुरी धरथिले सेमाने आम मालिक विजयबाबू हठात आक्रमण करने संगे संगे रविवारिक धरथिबा तेलेंगा कोटुरे विजयबाबू पिठी पटे गोटे चोट दबारे से रक्ताक्त हो जीवन बचाया जाई ट्रॉलर भितर को दौड़ी पशि जाइथिले तांको पछे पछे इसाक जापानी नन्नू पंडू विश्वजीत षंड गोड़े ट्रॉलर भितर को पशिथिले जापानी इसाक पंडू और नन्न धरतिबा पिस्तलु विजय बाबू ऊपर को धड़ाधड़ गुली चले
इमरान पछिन थिला
जापानी शेख इमरान alias जापानी I am also जापानी शेख इमरान alias शेख जापान alias शेख जापानी जापानी इसाक पंडू और नन्न धरतिबा पिस्तलु विजय बाबू ऊपर को धड़ाधड़ गुली चलेले
you have been implicated by a witness who is yet to be examined.
But my lord, this Pandu has been released, my lord. Pandu alias Assis has been released by this honorable court. I am passed.
Similar footing. And what is the cause of death of the deceased?
My lord, it's onset injuries.
Apart from that,
kindly see
criminal antecedent. 15 criminal antecedents.
Are the learned counsel for the petitioner and counsel for the state? The petitioner, Sheikh Imran, is stated to be in judicial custody since 15/4/2021. The learned counsel for the petitioner submitted that when the petitioner approached this court last time In BLAPL number 3103 of 2023, his bail application was disposed of as withdrawn. However, liberty was granted to renew the prayer after examination of material witnesses. Land Council submits that PW5 and PW5 na kono?
Lord, this Kalia Singh.
Kalia Singh and PW6 Sujay Das have been examined in the meantime, and they have not supported the prosecution case, and therefore the bail application may be favorably reconsidered. Land Council, however, submits that Sunil Mandal is another eyewitness to the occurrence who is yet to be examined, and Sheikh Manin, the eyewitness has been declined by the prosecution. He placed the statement of Sunil Mandal, which shows that the petitioner fired gunshot at the deceased, and the deceased died on account of the gunshot injuries. The London Council for the State submitted that there are as many as 15 criminal antecedents against the petitioner. Considering the submission made by the London Council for the respective parties, the overtact attributed against the petitioner, so also the criminal proclivity. I am not inclined to reconsider the prayer for bail stands rejected. The petitioner is at liberty to renew the prayer for bail after examination of eyewitness Sunil Mandal in the trial court. Yes. Same order in S.K.Sahoo.
My lord, in
Yes.
S.K.Sahoo, my lord, I have filed the comprehensive affidavit, my lord. Only two
Only
antecedents is
15
there.
criminal antecedent, what you say?
My lord,
Yes,
Sunil Mandal is, my lord, absconded till date, my lord. Several summons are issued to produce before the court below, but deliberately is not come to the court.
The
And he is
London
staying
trial-
out of state,
the
my lord,
London
West
trial
Bengal.
court shall make every endeavor to examine Sunil Mandal. Copy of the order be communicated to at an earliest courtesy. Yes. Next case.
Item number 56.
56, Mr.
Yeah.
Panda.
You have order dated 1/3/23 or 24. I am filing this comprehensive affidavit. In view of order dated 1/3/24, my lord, of your lordship, sir.
1/3/24.
I am filing this comprehensive affidavit.
Comprehensive. What is the period of detention?
My lord, 2/8/23 custody, man.
And what are the offenses under which charge sheet submitted?
274, 275, 120B.
274.
275, 120B.
120B. So earlier bail application was rejected.
No, my lord, earlier.
Then why it has come to me?
And some of the accused persons have been granted bail by your lordship.
Who are those accused persons?
Those are, my lord, Sahdev Panika, Bhavaleshwar Sahu, and Vishnu Hathi.
How many cases you have got?
Eight cases.
8 cases.
My lord.
What are the offenses?
Offenses, my lord, 8 numbers. One, my lord, 272, 274, 275, 120B. Then, my
52
lord,
Odisha
52
Excise.
Odisha Excise Act. Then, my lord, 379, 411, 414. Then, my
So
lord,
what have you stated? What is the status of those cases?
My lord, I have mentioned on all those cases he is in bail, my lord. And my lord, 2 cases have been closed.
Where have you stated that?
My lord, I have mentioned in para 4 of the affidavit, my lord.
Para 4.
Item 1.
Where is that?
Belpoda.
Para 4 of my affidavit. Item 1, my lord, Belpora PS case 125 of 21. Corresponding to city number.
What was seized in this case?
That cough syrup, my lord.
Cough syrup.
My
Heard the learned counsel for the petitioner and counsel for the state. Learned counsel for the petitioner submitted that the petitioner is in judicial custody since 2/8/2023. He has been charge sheeted under section 274, 275, 120B of the Indian Penal Code. Some of the co-accused persons have been released on bail by this court, and therefore the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail on the ground of criminal antecedents against the petitioner. Today, the learned counsel for the petitioner has filed additional comprehensive affidavit with regard to the criminal antecedent which is taken on record. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody, the release of the co-accused persons on bail, I am inclined to release the petitioner on bail allowed.
Item number 76.
May it please, Your Lordship. Item number 76.
Here,
Your Lordship may kindly have a glance to previous order, my lord.
there are two matters.
Yes, my lord. The lead matter is BLPL number 12306 of 2023. Both the accused are similar situated.
Both accused means this 12306 and 461.
My lord.
They are similarly situated.
My lord. Markonda Sodongi and Prasant Balwantara.
What is your submission?
My lord, previously, Your Lordship, I submitted the evidence, placed the evidence of PW1, mother of the deceased, and submitted that similar situated co-accused, namely Shankar Pradhan and Niranjan Maharana, who have also assaulted the deceased by different weapons, like the petitioner, have been released on bail. For that reason, Your Lordship, this Honorable Court directed, let the bail order copies of the co-accused person be furnished to the learned counsel for the state.
Have you furnished it?
Yes, Your Lordship.
Yes, my lord. I have gone through that also, Your Lordship. But in that case, Your Lordship, kindly glance Your Lordship order in Shankar Pradhan case, Your Lordship.
Shankar
Pradhan.
That is flag X, my lord.
BLPL 13325 of 2023.
Shankar Pradhan, yes.
My lord. Second page, Your Lordship. On 18/5/2018, I am placing from that, Your Lordship. On 18/5/2000, PW1 has mentioned that some of culprit committed the crime and assaulted the deceased, and she has not named the petitioner to be one of the assailant of the deceased on the date of occurrence. Learned counsel further argued that if PW1 and PW2 were the eyewitness to the occurrence, then first information report would have reflected their names. Well, but so far this present petitioner is concerned Guna Prasant Balwantara, his name is there in the FIR. But so far Markonda is concerned, my lord, his name is not there in the FIR. And in 161 statement as well as in PW1 and 2, they have categorically stated the name of Guna, Your Lords.
Your Lordship may kindly peruse the FIR, my lord.
Yes.
No, it's all right, Mr. What role has been attributed?
They have assaulted, all of them assaulted. That is the PW1 has stated categorically.
In the evidence, PW1 is the informant.
Yes, Your Lord. PW1 informant, PW2 is the informant, PW1 is the mother of the deceased, Your Lord.
And in the evidence, they have implicated the accused persons who have been released on bail. So also these persons.
Yes, Your Lordship has granted bail only because the FIR nata nothila. So far the other two person, my lord. But in FIR also his name is there. So far Guna Prasanta Balwantara is concerned. But the other person, the Markonda Sorangi, his name is not there in the FIR.
Are the learned counsel for the petitioner and counsel for the state? The learned counsel for the Dita common order kar devo. The learned counsel for the petitioner submitted that the petitioner Guna alias Prashant Balavant Rai is in judicial custody since
My lord, he is in 12/5/2018 your lordship.
12/5/2018
My lord.
and
My lord,
petitioner
sorry, 22/5/2018.
22/5/2018 and petitioner Markand Sadangi is in judicial custody since
1st August 2018.
1st August 2018 and they have been charge sheeted under section
302/34 of IPC.
34 of the IPC
25/27
and
arms.
25 and 27 of the Arms Act. He submits that similarly situated co-accused persons, namely Shankar Pradhan, has been released on bail by this court in BLAPL number 13325 of 23 as per order dated 19/12/23 and therefore the bail application may be favorably considered.
Another one.
Ji.
Another accused also granted on bail.
Pohuna di night of
Niranjan Maharana.
And Niranjan Maharana in
BLPL number 12412 of 2000.
BLAPL number 12412 of 2023
By
as
order
per order
dated
dated
18th December.
18/12/23. On the last date when the matter was taken off, the learned counsel for the petitioner placed the evidence of PW1, the mother of the deceased, and it was his submission that as per the evidence of PW1, the petitioners are similarly situated like the co-accused persons who have been enlarged on bail. Learned counsel for the state, after verifying the deposition copy of PW1, so also PW2, those submitted that in court they have implicated the present two petitioners, and the co-accused persons who have been enlarged on bail in similar manner, but the co-accused Shankar co-accused Shankar Pradhan was granted bail, was not named in the FIR as an accused. Considering the submission made by the learned counsel for the respective party, the nature of evidence adduced by the two eyewitnesses to the occurrence who have been examined as PW1 and PW2 in the trial court, and since similarly situated co-accused persons have been enlarged on bail and the petitioners are in judicial custody for about so and so years, kind to release the petitioners on bail allowed. Both the applications are allowed.
Item number 91.
Yes, Mr. Suchit Kumar Naik.
তারা আসছেনি এটা ভেরিফিকেশন অ্যাড্রেস ভেরিফিকেশন
Address verification. EP method. The learned counsel, দেখুন তো 91 অর্ডারটা এটা কত নম্বর রাখি লিখুন 91. The learned counsel for the state submitted that he may be given some further time to comply the order dated 14/3/2024 put of this matter on 2nd of August 2024. Yes, next.
Item number 94.
Procedural, sir.
Yes.
Sir, in this case, petitioner is languishing in the jail custody.
Earlier bail application was rejected.
Your Lordship has granted twice interim bail. That is in 2810 of 2021 for 3 months. Then in 14.
No, last time you were granted bail when? In which case?
1463 of 2023.
Where is that copy of that order?
That has been reflected in the Mallet order sheet also. Page, Your Lordship kindly see 30 page 34 Mallet. I have surrender also.
What about the witnesses?
I have also last occasion Mallet giving the deposition copy, including the eyewitness Mallet.
How many witnesses have been examined?
Mallet, I have given Mallet 8 witnesses, subsequently 3 witnesses, and they have also Mallet,
No, 8 witnesses are there.
I have given.
ତାପରେ ଅଛି କି 9, 10, 11 ଦେଇଛନ୍ତି ଦେଖିଲେ
ସେଥିରେ eyewitness ଥିଲେ
just a minute 8 ଯାଏ ଅଛି କୋର୍ଟ ରେ ଓ ଆପଣ 9, 10, 11 କେବେ ଦେଲେ?
Just now, chapter 9, 10, 11.
ସେ hostile ହେଇଯାଇଛି sir. ସେ ଯୋଉ eyewitness ଜଣେ ଥିଲା ଆଉ ସେ hostile ହେଇଯାଇଛି.
No, ଯୋଉ 8ଟା witness ହେଇଛନ୍ତି ମିସେସ୍ ସାହୁ
eyewitness
ସେ 8ଟା witness କଣ କହିଛନ୍ତି ୟା
Supported the
ବିଷୟରେ?
prosecution case.
ହଁ?
Supported the prosecution case.
No specific allegation against the
ଦେଖିବା କଣ କହିବେ କୋଉ witness କୁ କୁହନ୍ତୁ କୋଉ
PW
PW2, my lord, supported the
PW2
prosecution
just a
case.
minute ଦିଅନ୍ତୁ ସେଟା PW2 ପ୍ଲେସ୍ କରନ୍ତୁ କୋଉ ଲାଇନ୍ ରେ ଅଛି ତାର ୟା ନାଁ ହଉଛି ଦିବାକର କହଁର ନାଁରେ କଣ କହିଛି ସେ? PW2 ପରା କହୁଛନ୍ତି?
My lord.
PW2 କଣ ଦିବାକର ନାଁରେ କଣ କହିଲା?
Divakarna on the para 2, my lord. Running page 49.
ହଁ କହୁନାହାନ୍ତି କଣ ପଢୁନାହାନ୍ତି?
I can tell the name of some those villagers. They were Kalia Kahara and Dibakara Kahara. All these above named accused persons and the villagers who had gathered at the spot started assaulting us in our group. Parity Karana and Surat Naik were ahead of us. They both fell down on the ground being assaulted by the PW2, my lord.
In ST case number?
Na Suddam Hathi.
ସେଟା previous ସେଥିରେ acquittal ହେଇଯାଇଛନ୍ତି.
No, ଏବେ ଯୋଉ deposition ଦେଇଛନ୍ତି
ସେ ପଛରେ ସେଟା previous case ସେମାନେ ସବୁ acquittal ହେଇଯାଇଛନ୍ତି. All the 5 person has been acquitted.
ଏବେ ଯୋଉ deposition ଦେଇଛନ୍ତି
ତା ପୂର୍ବ ସେବେ ଦିଆ ହେଇଥିଲା ଆଗରୁ ଦିଆ ହେଇଥିଲା ନା ପଛରେ ଥିଲା ନା ଆଗରୁ ଦେଇଥିଲେ ପୁରା ପଛରେ ଅଛି ଲାଷ୍ଟ କୁ
ଆପଣ କାଇଁ କନଫ୍ୟୁଜ କରୁଛନ୍ତି ST 61 ST 30 ନା କଣ
এটা previous case ରେ ମୁଁ ଦେଇଥିଲି ସେମାନେ acquittal judgment of acquittal ଦେଇଥିଲେ ପଛରେ ପୁରା ଲାଷ୍ଟ କୁ
acquittal ଆପଣ deposition ଦେଲେ ମୁଁ କେମିତି ଜାଣିବି
ପଛରେ ଅଛି ଦେଇଲି
ସେଇଟା ଦେଇଛନ୍ତି ଆଜ୍ଞା
ନା
ଏ କେସ୍ ରେ PW1 କିଏ?
PW1 informant ମାଇଲଟ
ଆରେ ତା ନାଁ କଣ?
ଅମୀର
କର୍ଣ୍ଣ ଦେଖିଲେ ଆପଣ ପାର ଅଛି ଅମୀର କର୍ଣ୍ଣ
ଓ ଲାଷ୍ଟ ରେ ଦେଇଛନ୍ତି देखिए सेपरेट ଦେଇଛନ୍ତି
PW2 ଟା କିଛି କାଇଁ ଦେଖାଉନି ଦିବାକର କହଁର ଏବେ ଯୋଉ ହେଲେ 8 ଜଣ ୱିଟନେସ୍ ତା ଭିତରୁ କିଏ ଆପଣ ନାଁ କହିଛି?
ମାଇଲଟ କେହି କହିନାହାନ୍ତି नो
ସ୍ପେସିଫିକ ଅଲଗା
ନା ଟୋଟାଲି ନା କହିନାହାନ୍ତି they have not named my name not mine
nobody has named you?
yes माइलट PW One is the informant. He has category Chittaranjan Kaur, Uddhava Kaur, Angura Kaur, Dasharatha Kaur, Ratnakara Kaur, Rindha Kaur, Guttu Kaur, and 4 to 5 other persons. Then my lord PW2, he has also
କେବେଠୁ ରହିଲେଣି କଷ୍ଟଡିରେ?
my lord 20 my lord 16/3/2020.
16/3/2020
Yes my lord.
ଦିଥର
Yes
ଯାଇଛନ୍ତି
my lord. Yes my lord.
interim bail ରେ
Yes my lord.
for how many months?
3 months my lord.
Last time ଯାଇଥିଲେ ଯୋଉଟା କେବେ?
My lord on 28/7/2023. And
BLAPL number
1463/2023. And also surrender after page 34 surrender on
34.
Yes my lord. I have also surrendered duly identified and Divakar Kaur was surrender on but
RG Learned Counsel for the petitioner, Learned Counsel for the state. The Learned Counsel for the petitioner submitted that the petitioner was taken into judicial custody on 16/3/2020 and twice he has been granted interim bail, each time for a period of 3 months, and after availing the same he surrendered at right time and he has never misutilized the liberty. It is further submitted that as on date in the trial court, 11 witnesses have been examined by the prosecution and not a single witness has stated anything against the petitioner, and therefore the bail application may be favorably considered. Learned Counsel for the state oppose the prayer for bail. Peruse the evidence of the witnesses examined so far in the trial court, considering the period of detention of the petitioner in judicial custody, progress of the trial. Counsel has failed to bring anything adverse against the petitioner to have misutilized his liberty during the period of interim bail. I am inclined to release the petitioner on bail allowed. Wait a minute. Yes.
Item number 98.
Mr. Rajesh Kumar Mahapatro. Nandi. Next.
Item 101.
101 Ramakanto Ponda. For the first time, he was released on interim bail, so and so, but he did not surrender, for which NBW was issued. And on so and so, you surrendered. And then out of 32 charge sheet witnesses, 7 witnesses have been examined. That is the report. Period the prisoner's petition. Case number 8. And it's at flag G, in which prayer has been made to engage Mr. Suroj Maharana as his advocate. Mr. Maharana has filed Wakalatnama, which is accepted, submitted by the learned counsel for the petitioner, that the petitioner was taken into judicial custody on
My lords, 22/11/2022.
22/11/2022.
2020, my lords. My lords.
And he was released on bail, interim wise. And the last time when he was granted bail, he surrendered at right time. And since there is delayed disposal of the trial, the bail application may be favorably considered. Status report submitted by the London trial court indicates that out of 32 charge sheet witnesses, 7 witnesses have been examined so far. 3 months bail granted. Yes, next.
Last appeal lordship directed to whether he misutilised the liberty or not, the instruction
What has
obtained by
anything against?
no matter.
Acha. As for the order dated sworn so, the London Council for the State has obtained written instruction from IIC Bhanjanagar Police Station that the petitioner has not misutilized his liberty while on interim bail. The written instruction is taken on record. Yes, next.
Obliged.
Item number 124.
19.
Mr. Dilip Kumar Mahanti.
May I please your lordship? My lord, petitioner was twice released on interim bail and each time for 3 months, my lord. And on each occasion, he surrendered in time, my lord. And
now, as it appears, out of 38 charge sheet witnesses,
only 8 witnesses have
been
been examined. And the case was charged, my lord. I have the certified copy.
So what Yes, next. Kete dakile? 120? 125. Yes, sir. 124 गला पर एटा कोटा
24 गला
अब see same advocate लिखाई जी तो गला नहीं भेजी अब छाड़ो next item रख
129.
May I praise your lordship?
129 yes
May I praise your lordship? Here in this case, my lord, the
mention colony
here the
100.
basis of involvement is confessional statement of co-accused, my lord. Allegation is that
अब
the
किसी नहीं
that is the allegation. My lord.
Mr. Neller are the learned counsel for the petitioner learned counsel for the state considering the submission made by the learned counsel for the petitioner that the petitioner was taken into judicial custody on
My lord, 19/1/2024
19/11
एक my lord
1/2024 and his implication in the case is based on confessional statement of co-accused before police which is not disputed by the learned counsel for the state and since no incriminating article has been seized from the possession of the petitioner keeping in view the ratio laid down in the case of Tofan Singh I am inclined to release the petitioner on bail eta kodiga loko
my lord both my lord both my lord
on the article allowed
I will submit my lord item 125.
पढ़ेले कौन
I
बेल ହେଇଗଲା ବୋଲି ଖୁସିରେ ପଳେଇଲେ
no, I'm sorry.
yes
My lord, in this case,
120 yes କରନ୍ତୁ
let it come, my lord, next week.
next week
Next.
all right next week ରେ ତ ଆସିବ
Aye.
yes
Item number 133.
133 yes Mr. Ponda
May I please, my lord? The petitioner is in custody since 7/3/2020.
7/3
2020. 20B2C of NDPS Act. Quantity of ganja involved 42 kg 250 grams gross weight. Net weight 41 kg 850 grams.
ଯାଇଥିଲା ଆଗରୁ
Once interim bail granted for a
କେବେ?
period of 3 months.
କେବେ
I'm coming.
in PLP
Page 9. Page 9 BLAPL 9013 of 2020 by order dated 7/4/2022.
ଠିକ ସମୟରେ surrender କରିଛନ୍ତି
ଠିକ ଟାଇମରେ surrender କରିଛି. Then this honorable court page 11 in BLAPL 8678 of 2022 has directed the since the petition para 5 my lord since the petition is stated to be in custody from 7/3/2020 learned court in session is called upon to expedite trial and conclude the same within a period of 2 months from the date of receipt and production of
କଣ ହେଲା ବର୍ତ୍ତମାନ position କଣ
position. Total 8 witnesses have examined out of 22 charge sheet witnesses. More than 4 years in custody. Mohammed Muslim.
are the learned counsel for the petitioner and counsel for the state the learned counsel for the petitioner submit that the petitioner is taken into judicial custody since 7/3/2020 and he was granted interim bail for a period of 3 months in BLAPL number
9013 of 2020.
9013 of 2020 as per order dated 7/4/2022 7/4/22 ହେଲା and after availing the same he surrendered at right time when he approached this court second time for bail in BLAPL number 8678 of 2022 this court by order dated 4/5/23 directed the London trial court to conclude the trial within a period of 2 months from the date of receipt of the order. He submits that out of 22 charge sheet witnesses, only 8 witnesses have been examined and therefore the bail application may be favorably considered. State Council opposed the prayer for bail, 3 months bail granted. Yes, next.
And I may pardon? 3 months.
Yes. କମେଇ ଦବା କି?
ଆଜ୍ଞା
କମେଇ ଦବା.
ନାଇଁ 4 months କଣ 4 ଲୋକାଲ ଲୋକ 4 months କଣ
Next. Yes.
Item number 141.
Petitioner is in custody since 11/9/2019.
141. କେବେଠୁ ରହିଲେଣି?
11/9/2019.
2019.
ଆଜ୍ଞା 21C of the NDPS Act.
ଯାଇନାହାନ୍ତି
300 grams of brown sugar.
bail ଯାଇନାହାନ୍ତି?
Twice Miller's interim bail has been granted.
Last time କେବେ ଯାଇଥିଲେ?
The last interim bail was granted by the Honorable Court on 6/4/2023. In BLAPL number 2289 of 2023.
3 months ଯାଇଥିଲେ.
ଆଜ୍ଞା page
Surrender କଲେ ଠିକ ସମୟରେ?
ଆଜ୍ଞା ତାପରେ he went to the Supreme Court.
କଣ ହେଲା?
The Supreme Court interim order was there. Subsequently, it was withdrawn. That order I have given at page 42 of my brief.
42.
Yes.
6 permission to withdraw the application.
But interim order was granted at page 41.
Mhm.
Honorable Supreme Court has granted interim order at page 41.
ବର୍ତ୍ତମାନ position କଣ?
But out of 13, my lord, 6 witnesses have been examined. That is the rejection order it shows. And all 6 witnesses have declared hostile.
Are the learned counsel for the petitioner and counsel for the state? The learned counsel for the petition submitted that the petitioner was taken into judicial custody on 11/9/2019 and he was released on interim bail for a period of 3 months as per order dated 6/4/23 in BLAPL number 2289 of 2023, and after availing the same, he approves the he challenged the order of this court before the Honorable Supreme Court in SLP so number dekhidev annexure 4 series, and though the interim bail order was directed to continue as per order dated 11/7/23, but on 2/1/2024 the petition was dismissed as withdrawn. The rejection order kebe kara apun?
This rejection 11/3.
Thereafter you surrendered.
Okay. 11/3/2024.
Thereafter the petitioner surrendered in the court below and moved for bail. The learned counsel for the petitioner submit that the petitioner that out of 13 charge sheet witnesses, 6 witnesses have been examined so far in the trial court. Learned counsel for the state has failed to produce anything that the petitioner has misutilized the liberty.
But he
has
not misutilized their liberty also.
The produce the instruction that the petitioner has not misutilized the liberty. Report from the IAC Khandagiri police station, hello. And the health condition of the father of the petitioner, as per the medical report relating to this one, so it is a genuine one. Hello. And the father of the petitioner is suffering from initial stage of stomach cancer and is stopped. The written instruction is taken on record. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody, slow progress of the trial, and since the petitioner has not misutilized, 3 months bail granted. Yes, next.
Item number 143.
143 minute. In this case, petitioner is remanded on 13/7/2021 and he is in custody 30/11/2020 in another case, that is BLPL number, second case of serial number 3130 of 2020. And all accused persons are bailed by this honorable court.
This petitioner is the is the first one. And what is the second one?
Second one is Lalbagh PS case number 294/2020.
Then why you said that it is not the same? I said that it is
This
two
is
different.
matter of IIFL.
It's all right. I just asked you question whether it is the same FR or different.
No, different FR, my lord, sir, different FR.
So what you say? You are taken into custody on 13/7 and co-accused persons released on bail.
Yes, my lord.
Yes, Mr.
Yes, my lord. In some cases, where there is 20 and other offences are there, they are released on bail. But in the case of 290/20, there is 395.
No.
Mr. 3117 first question.
Yes, my lord. 420 allied offence.
3117 देवड़ा सब magistrate tribal offence.
Tribal offence.
Just go to the learned counsel for the petitioner submitted that the petitioner Nilamani Saha is in judicial custody since 13/7/21, right?
Yes, my lord.
And he has been charge sheeted under sections kondu.
Under section 420, 406.
Yes.
409, 467, 468, 471, 379, 120 and 34 IPC.
And similarly situated co-accused persons have been namely Saroj Kumar Prusti,
Yes, my lord.
Kamal Lala, Amrit Sagar Roy, and others have been granted bail by this court.
Yes, my lord.
He has annexed the copies of the bail order to this application as Annexure 3 series.
Yes, my lord.
And submits that on the basis of claim of parity, the bail application may be favorably considered. Learned counsel for the state doesn't dispute that the petitioner is similarly situated like the co-accused persons who have been enlarged on bail. Considering the submission made by the learned counsel for the respective parties, period of detention in judicial custody, release of the co-accused persons on bail, and since the offences are triable by magistrate, I am inclined to release the petitioner on bail allowed. What about the next one?
Next one, my lord, BLPL number 3130 of 2020. In this case, 30/11/2020 petitioner was arrested and charge sheet under section 120B, 409, 420, 411, 34
bail.
IPC.
Annexure 3.
Yes, ma'am.
Mr. Again,
Yes.
these are all magistrate
Yes.
tribunal. So, ताদের same थी लिखिवे order same कर दें allow कर दें. Yes, next.
Yeah, the 395 is there.
Who did it?
इधर लिखा है order.
No,
Order लिखा है
Please.
All are no allegation are not made out on all accused persons. Same allegation are not that. Same allegation.
Please come to the rejection order at Annexures 2. Mr. Tripathi.
Yes, Mr.
Annexure 2 which rejection order. Page 17.
Yes, Mr.
Please see paragraph number 4. The accused petitioner is facing trial for the offences under 120B, 409, 420, 411 by 34 of the IPC. All right, next.
Item 145.
145 BLPL number 3132.
कौन
FR
Other jason the co-accusation the
Yes, Miller.
Same
yes,
order.
yes.
All right. Next.
I oblige.
Item 154.
May I please, your lordship? That here, my lord, the petitioner is in custody since 4/3/2024, my lord. BLPL number 3820. First time.
154 BLAPL 3820.
20, my lord.
2024. What is your date of custody?
4/3/2024, my lord.
What are the offenses?
My lord, 147, 148,
Just a minute. 147, 148.
326,
Yes.
307, 302, and 149 of IPC, my lord.
So your bail application was earlier rejected.
No, my lord. This is my
First time.
My lord.
Then why it has come before me?
My lord, tired of matter.
Tired of matter.
My lord.
Anybody has been released on bail
My
by the
one Ganapati Gowda, my lord. BLFL number 4697 of 2019, my lord. The bail order is at flag A, my lord.
As for the statement of eyewitness Ghasiram Pujari, who is an NGO and happens to be the father of the deceased Gupta Pujari, three co-accused persons, namely Nabha Gowda, Jairam and Balaram, participated in his assault. So far as the assault on the deceased Gupta Pujari is concerned, allegations are omnibus in nature. State Council placed the eyewitness statement Ghasiram Pujari. Postmortem report also placed. Okay. You claim parity with this accused.
Mine.
So who is this petitioner who has been in that 4697 has been released on bail?
Ganapati Gowda.
Ganapati Gowda. 4697 2009.
Yes, for antecedent.
Offense कौन?
Previously,
file कौन तो वो comprehensive affidavit. The learned counsel for 4 criminal antecedents. Let the learned counsel for the petitioner obtain instruction in respect of such antecedent and file a comprehensive affidavit relating to the status of those cases. केबे फाइल करिवे?
By next week.
By next week माने 26 तारीख रे आनिबी ना तापर week रे आनिबी?
26 तारीख.
26th of so and so. You take the numbers of those 4 cases.
Mine.
Yes, next.
Next second item.
Which one?
4012.
4012. Yes, आरो भास्कर सागरिका सेई केस रो अराइज करछि.
My lord.
यार अछि criminal antecedent.
Yes, my lord. He has 4 criminal antecedent. Out of those,
same
my
same
lord.
order. फाइल करंतु comprehensive affidavit करी दियंतु एथरे बेल हेछि एथरे खलास हेछि पोजीशन सोडा देगिन 26 तारिख आसीबो 26 July 2024 comprehensive affidavit to be filed. Yes.
Item 155.
155. Mr. Mahanti.
may I please, Your Lordship? Your Lordship, in this case, from last occasion, a status report was called for, my lord.
Charge has been framed. 396 is there.
Yes, my lord.
25 1B 27. Prosecution witnesses ala 38 ରୁ 19 ଟା ହେଇଗଲାଣି ଆଉ decline ହେଇଛନ୍ତି ଗୁଡା witness. So have you got the deposition copy of those witnesses?
My lord, in this case, my lord, I am in custody since, my lord, last 7 years, my lord. And
It's
due
all
to
right,
such,
but it's a case under 396.
Yes, my lord. But due to such delay ground, my lord has allowed a bail application. That is, my lord, is Annexure 3, my lord.
Annexure 3.
Annexure 3, my lord. Annexure 3 in page 17, my lord. My lord has clearly elaborated that, my lord. The inordinate delay in disposal of the trial, I am inclined to leave the petition on bail.
No, so many things have been there.
Yes.
There was no criminal antecedent. Then statement of so and so was placed and
similar footing, man.
31 2017. So what is your submission, Mr. Das? Asini. All right. The Learned Counsel for the state seeks some time to obtain instruction about the produce the case diary, so also obtain instruction about the criminal antecedent anyway. 396 case ta.
9242.
କୋଉ ଥାନାରୁ ଆସିବ?
ହଳଦୀବାଡି
26 ରେ ରଖିବି ନା ଉପରେ?
ନେକ୍ସଟ ୱିକ୍ ତାପର
ନେକ୍ସଟ ୱିକ୍। ହଁ ତାପର ୱିକ୍।
ଆଜ୍ଞା।
ଆଚ୍ଛା 2 ତାରିଖ 2nd August 2024 CDCA. Yes, next.
Item 156.
156, yes.
My Lord, 20B2C. Petitioner was earlier granted bail for a month. He didn't surrender, and thereafter he was arrested. In the meantime, my Lord, another accused person standing on the same footing has already been released by your Lordship. And last time, your Lordship was pleased to direct the registry to obtain the status.
BLAPL number?
The PL number, my Lord. BLAPL number 2012 of 2021. I was granted bail for a month, but due to non-surrendering, he was once again arrested in 2024. And the co-accused, my Lord, it is with me. That is, your Lordship was pleased to allow bail, and so far as the petitioner is concerned against him is that he, after being released on bail for a month on the ground of health condition of his wife, he didn't surrender. And that bail application of Biswajit Patra 3238, I am having a copy.
No, that is there, but I think the observation is like this.
Yes.
No contraband was seized from the possession of that petitioner, and he was implicated basing on the confessional statement of co-accused.
No, my Lord, both were arrested from this spot.
No, that was the
Your Lordship, let the petitioner be released on bail.
No.
Diary submitted that certain document have been seized relating to the transfer of the vehicle, and the case diary doesn't reveal the availability of any criminal antecedents.
Also the FIR.
Sir, on being asked, they disclose their name as Joseph Bisoi, son of so-and-so, district so-and-so, and Ramesh Bidika, son of so-and-so of Raigada. They confessed that they were transporting contraband ganja in 4 plastic gunny bags without any.
Where these persons were released? He was apprehended at this spot.
My Lord, they were, because that is the when the petrol.
Please see the FIR.
Yes, my Lord.
FIR रे कहूची जो 2 जण धरा पड़िले सेमानकर ना होची जनक ना होची जोसेफ बीरो।
प्रेजेंट पिटिशनर जोसेफ बीरो
के प्रेजेंट पिटिशनर आउ जनक ना होची रमेश बिडिका जहाकू बेल मु देइथिली ता ना होची विश्वजीत पात्र।
That is true.
ताले आपण सेम फुटिंग केमथि हो?
In the same case, not same footing. I am sorry.
That is a distinction. Vishwajit Patra, whom I have granted bail, his implication is based on confessional statement of co-accused.
That is true.
Whereas you were arrested, apprehended at the spot with the contraband ganja of commercial quantity.
Commercial quantity.
So how do you claim parity with that man?
Not parity. I am
then
not.
What is your submission?
I am not claiming parity.
Then
But my submission before your lordship is that since the trial has not been started, since 2020, the petition, the
but you have been tested and it is found that you
Well,
are
that is one against me. That is true. I am admitting that. But since 2020, the FIR is since 2020, and the trial has only just
କଣ
begun.
କହନ୍ତି ଭାତ ହାଣ୍ଡିରୁ କଣ
ଗୋଟେ
ଗୋଟେ
ଚିପିଲେ
ତେଣୁ ଆପଣଙ୍କୁ ଦିଆହେଲା ମାସେ ଆପଣ ସରେଣ୍ଡର
ସେଟା
କଲେନି
ସେଟା
ତେଣୁ
ଠିକ ଅଛି ଯେ କିନ୍ତୁ ଗୋଟେ ଥରରେ ବି ତ ଟେଷ୍ଟ My lord, I am a local
learned
person.
counsel for the petitioner, learned counsel for the state, learned counsel for the petitioner submit that the petitioner is in judicial custody since 12/11/2020, and in the trial court, out of 18 charge sheet witnesses, only one witness has been examined, and one of the co-accused, namely Biswajit Patra, has been released on bail by this court in BLAPL number 3238 of 2021 as per order dated 10/8/2021, and therefore the bail application of the petitioner may be favorably considered. Learned counsel for the state, on the other hand, opposed the prayer for bail and submitted that Biswajit Patra's implication is based on confessional statement of co-accused, and the petitioner was apprehended at the spot with commercial quantity of ganja. He further submitted that the petitioner was granted bail for a period of 1 month earlier by this court in BLAPL number so and so, which he has misutilized and did not surrender at right time. Here you the status report furnished by the London trial court, which also indicates that out of 18 charge sheet witnesses, one witness has been examined. Considering the submission made by the London counsel for the respective parties, period of detention of the petitioner in judicial custody, and progress of the trial so far, I am inclined to release the petitioner on interim bail for a period of 3 months, subject to condition he shall appear before the London trial court on each date and shall not indulge in any criminal activities, violation of any terms and conditions, shall entail cancellation of bail. Yes.
My lord, there is a mistake. In 2020, I was arrested and released on bail. Thereafter, once again arrested on 11/1/2024.
11/1/2020.
2024.
24. Yes.
Yes.
Next.
Oblige.
Item 159.
Yes. Mr. Saubhagya Sundar Das. Next.
Item 167.
May it please your lordship. Alice offences is your lordship 22C of NDPS Act. This is the second journey, your lordship. And in the meanwhile, two co-accused persons have already been released on bail, and three witnesses.
When he was taken into custody?
18/8/2023, your lordship.
Okay.
And one Dharmu alias Dharmendra Majhi, he has been released on bail by the BLAPL.
You were apprehended at the spot.
No, your lordship.
Your implication is based on co-accused confession.
Confession police report investigation रे से कहले जे एमाने थिले on the spot थिले देखिकी दौड़िकी पळेले गां लोक कहिले
ये कोन स्पॉट रे धरा पड़ला ना परे माने
परे सरेंडर कला सो मोटो
स्पॉट रे को मन धरा पड़ले
केही नुहंती गोटे ड्राई पॉन्ड गवर्नमेंट प्ले जगारू से माने सीज करथिले as per the prosecution report से माने सीज करथिले and three
ए माने पळेले बोली की कहला
गां लोक कहले बोली पुलिस कहला
अच्छा
and 3 witnesses have already been examined. I have annexed that, your lordship, as annexure 2 witnesses have turned hostile with seizure to witness to seizure.
Confidential inquiry found that.
How kichi case bas achi?
No, your lordship.
But last occasion bail ta
Last occasion?
BLAPL 9843 of 2023. Though he was 10 years absconder, direction was made to conclude the trial within 6 months.
He was given liberty also.
My lord.
That it was 6 months. So now what is the position, madam? How many witnesses have been examined?
Out of 15, 3 witnesses have.
3.
I've annexed those, Your Lordship. 2 hostile ହେଇଗଲେଣି 2 ଜଣ witness to Caesar.
Or the learned counsel for the petitioner and counsel for the state. The learned counsel for the petitioner submitted that the petitioner was taken into judicial custody on 18/8/2023. And when he approached this court last time for bail in BLAPL number 9843 of 2023, as per order dated 15/12/2023, while rejecting the application for bail, the London Trial Court was directed to expedite the trial and conclude the same within a period of 6 months from the date of framing of the charge, and the petitioner was given liberty to renew the prayer for bail if the trial is not concluded within the said period. The learned counsel for the petitioner submitted that only 3 witnesses have been examined out of
15, Your Lordship.
15 charge sheet witnesses, out of which 2 have not supported the prosecution case. The learned counsel further submits that the petitioner was not apprehended at the spot, and therefore the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail, considering the submission made by the learned counsel for the respective party. Since the order of this court dated 15/12/2023 has not been complied with, I am inclined to release the petitioner on interim bail for a period of 3 months. Yes, next.
That is 16 charge sheet witness. Not 15, 16 charge sheet.
16.
16?
Charge sheet
Witness.
16 अच्छा 16 कर दे.
168 मारा.
अब बाकी ରହିଲା କାଲି next week ଆସିବ.
168 next week. 160. ପଛକୁ ପଳଉଛି.